Good morning, everyone. My name is Garnet Hanley, and I'm the Chief of the Competition and Infrastructure Policy Division within the Wireless Bureau. For those unfamiliar with our organizational structure, the division supports compliance with the National Environmental Policy Act and the National Historic Preservation Act, as well as the environmental notification process required for antenna structure registration. These are all topics we are pleased to have the opportunity to review with you today. I'm pleased to welcome everyone today, both those in person and those participating virtually. Before we start with our first speaker, I would like to walk through a few housekeeping matters. Given this is a hybrid event with both in-person and online participation, I would like to note to everyone that we will have speakers who will present both in person and some will present virtually. We have a lot of material to cover today, and I imagine many in the audience will have questions about the topics. Once each panel concludes their presentations, we will have some time at the end for questions and answers. We have over 400 participants today, so we cannot guarantee we will get to all of the questions, but we will do our best in the time allotted. I ask that you send all your questions via email to FCC Environmental Workshop at fcc.gov. We also ask in-person attendees to email their questions to FCC Environmental Workshop at fcc.gov because it might be difficult for those online to hear the questions. As you might have seen, there are several pamphlets in the back of the room with the Wi-Fi code in case the in-person participants are having difficulty accessing email. Also, for those in-person participants, we have confirmed there is no food permitted in the room. I apologize. So I encourage everyone to keep that in mind for the 45-minute lunch break. Also, I would like to introduce Carrie Hicks, Associate Bureau Chief of the Wireless Telecommunications Bureau. Carrie, please stand. Thank you. Thank you, Carrie. And Carrie today will be helping with the questions and answers sessions for several of the panels. And now, I'm pleased to introduce Joel Taubenblatt, the Acting Bureau Chief of the Wireless Telecommunications Bureau, to provide some introductory remarks. Joel?
Thank you, Garnet, and good morning, everyone.
Joel, I apologize. They just told us they're having some problems with the live feed. So if we could pause it for 1 minute. Okay. We're good.
All right.
Thank you. Sorry, Joel. Yeah.
Sorry.
We're good?
We're good now. We just got the thumbs up.
All right. We'll try take two. Good morning, everyone. All right. That was even better that time. Well, welcome to the FCC's 2022 Environmental and Historic Preservation Workshop. It's great to be here, and we have a great agenda for you today, and we're really looking forward to giving you a comprehensive overview of the FCC's environmental and historic preservation rules and policies, as well as some related FCC online systems. I'm very pleased today to be able to welcome speakers from several different bureaus within the FCC, from the NTIA, and from environmental expert agencies, including the ACHP, CEQ, and U.S. Fish and Wildlife. We work very closely with our colleague agencies, and we appreciate their willingness to be here to provide and share their expertise. Whether you're an FCC licensee, a tower builder, a historic preservation officer, a consultant, or a member of the public, we thank you for taking the time to be here with us today for this important training. Your role in the process of reviewing and deploying wireless infrastructure is absolutely critical. During the last few years during the pandemic, we've seen the importance of communication services across the country, including wireless services. We've seen how it's kept people connected. We've seen how it's changed the way that people interact with work, with schools, with their medical service providers, and with their family and friends. And we've seen how all of you have adjusted during this period of time to try to make sure that the review and deployment of wireless facilities can continue. And that's yielded the expansion of coverage to rural and underserved areas, the expansion of coverage to schools and to hospitals alike. And we've appreciated the opportunity to collaborate and work with all of you as we try to facilitate the benefits of the deployment of wireless facilities to the public, as well as, importantly, the protection of this nation's environmental, historic, and archaeological resources, including tribal cultural resources. We really enjoy doing these trainings because it gives us an opportunity to share information, gives us an opportunity to learn perspective from all of you and to hear expert speakers here today. And also your questions and your participation will help us think ahead to how we might continue to enhance our processes here at the FCC. The work that we do is critically important, and it is great not only to see everyone here in person, but also for this to be a hybrid event where we can extend the reach of our workshop and allow people to participate in however way that they feel most comfortable. And in fact, maybe some of the folks who are participating are using these same wireless services that we are devoting this workshop training to. I'd like to thank the folks from the FCC's tech team for helping us put together this hybrid training. I'd like to thank folks from the Wireless Bureau and other bureaus and offices for their very hard work in putting together this training. I'd like to thank the team at the FCC who works so hard on historic preservation and environmental issues, and as well our government colleagues who are here with us today and who we appreciate closely collaborating with. So with that, I hope that you very much enjoy this workshop, and I will turn it back over to Garnet. Thank you.
Thanks, Joel. Thank you, everyone. And now, I'm pleased to announce our first panel on environmental rules and enforcement overview. George Liris, Associate Chief of the Competition and Infrastructure Policy Division of the Wireless Bureau, and Shannon Lipp, Assistant Division Chief of the Spectrum Enforcement Division of the Enforcement Bureau, will participate in this panel in person, and Daniela Aragua, Attorney Advisor of the Enforcement Bureau, will present on these topics virtually. George, I'm going to hand it over to you. Thank you.
Thank you, Garnet. Good morning, everyone, from me too. This session will provide an overview of our environmental rules and enforcement. I will start with our environmental rules, and my colleagues from the Enforcement Bureau, Daniela and Shannon, will take over for the enforcement. Next slide, please. So, let's tackle the elephant in the room. We are here for the National Environmental Policy Act. This is why we're all here today, and you'll hear about it a lot. NEPA, it requires agencies to consider and disclose the environmental effects of their actions to improve decision-making and encourage transparency, public participation, and accountability. Effects are defined broadly. NEPA also requires agencies to integrate environmental considerations into their decisions and establish a process for environmental review. But NEPA does not mandate a specific outcome. All major federal actions significantly affecting the environment trigger environmental review. And as we all know, context is key for NEPA review. A 1,000-foot tower in a national park will be treated differently than collocating on a lamppost in an industrial zone. NEPA establishes 3 levels of review. We'll start with the less strict and go to the stricter. Categorical exclusions, or CATXs. These are for actions or types of actions that individually and cumulatively are deemed to have minimal or no impacts on the environment. These actions therefore qualify as excluded from detailed environmental analysis. Environmental assessments, or EAs. For actions that may have a significant environmental effect, an EA is prepared to analyze potentially significant impacts. If no significant impacts are found, the agency issues a finding of no significant impact, a FONSI. And the last, the stricter, the most burdensome environmental impact statements, EISs, for major federal actions with the potential to significantly affect the quality of the human environment. These actions require a detailed analysis of actions and alternatives and conclude with a record of decision. Next slide, please. How does the Nhpa apply to the FCC? Building new towers, modifying towers, or collocating antennas on existing structures requires compliance with the FCC's rules for environmental review. Also, towers requiring antenna structure registration are subject to environmental notice rules to provide the public an opportunity to identify potentially significant environmental concerns. The FCC's environmental review rules ensure that entities constructing facilities to support FCC licensed services take the appropriate measures to consider an environmental and historic resources, and that the agency meets its various statutory obligations. You'll see below what you're all familiar with, the Nhpa umbrella. These are our various statutory obligations that we have to meet. Next slide, please. How does the FCC implement Nhpa? It implements its Nhpa obligations by imposing enforceable duties on licensees and applicants through its environmental rules, and we'll talk a lot about them today. These rules apply to all licensees, applicants, registrants, and owners of facilities used for FCC licensed services. Tower owners that are neither licensees nor applicants must also follow these rules if they intend to host antennas supporting FCC licensed services. And the FCC delegates the initial assessment of potential environmental effects and the determination of whether Cat X's apply to applicants constructing facilities to support the use of FCC licensed services. What are our Nhpa rules? You can find them at 47 CFR 1.1301 to 1.1320, and there are other rules as well. The FCC's Nhpa rules categorically exclude from environmental processing most commission actions with respect to any new application or minor or major modifications of existing or authorized facilities or equipment. There are exceptions. Actions that involve certain site locations and high-intensity lighting or that exceed radio frequency safety standards require environmental processing. And specific site location considerations are spelled out that require environmental processing are also spelled out in 1.1307. You can find a lot about our Nhpa rules on the Nhpa checklist tool. That's on the Commission's tower and antenna siting website, and that assists applicants in identifying when an environmental assessment is triggered under Section 1.1307. The Responsible Bureau may also order an EA when an interested person alleges that an otherwise categorically excluded action will have a significant environmental effect. But in that case, the Responsible Bureau would need to determine that the project may have a significant environmental effect. And finally, the Responsible Bureau may also order an EA on its own motion. Next slide, please. The categories of facilities requiring an EA include those that are in a wilderness area, most likely on federal land, or in a wildlife preserve, likely on federal land. Those that might affect threatened and endangered species or their habitats. Those that might affect properties included in or eligible for inclusion in the National Register of Historic Places or Indian religious and cultural sites. Those that will be located in a floodplain where the facility equipment will not be placed at least 1 foot above the base flood elevation. Those facilities whose construction will involve significant changes in surface features. Those facilities that might affect migratory birds if the towers are over 450 feet. And those facilities that involve high-intensity lighting in a residential area. Next slide, please.
I think they're one behind. Yeah.
Oh, well, thank you very much. I appreciate it. Well, you've heard me speaking about the 1307A, so we'll move to the next slide. Thank you. Complying with the FCC's environmental rules requires completing an analysis of the categories just mentioned and making a determination as to whether there may be a significant environmental effect prior to completing FCC applications. For example, Form 601 or Form 854. And here is a simplified, extremely simplified overview or flowchart of our Nhpa process. You, the applicant, must determine whether an action may have a significant environmental effect. If the determination is no, please retain documentation of your environmental review. If the determination is yes, please prepare and file an EA. The EA then goes on public notice for 30 days. The Commission reviews and accepts public comments on the EA. If any issues remain, the applicant must amend the application to eliminate those issues or prepare an environmental impact statement. If no issues remain after the Commission's review, then the FCC issues a finding of no significant impact. As a reminder, in bright red letters, regardless of an applicant's determination, the FCC may order environmental review of a facility pursuant to a request by an interested person or a Bureau's own motion. So the next few slides, next slide please. The next few slides will provide just a teaser trailer of what you'll hear about in detail in the rest of the sessions. You'll hear about Endangered Species Act. Applicants must consider the impact of proposed facilities on sensitive species and their habitats, including communicating with the U.S. Fish and Wildlife Service. You'll hear about migratory birds. Applicants must prepare an EA that considers the effects on migratory birds when a proposed antenna structure will be over 400 feet above ground level. And my colleague Deborah Spring and our colleague from the U.S. Fish and Wildlife Services, Joel Gehring, will address these rules and requirements. You'll also hear about the National Historic Preservation Act, NHPA. The FCC's Npa rules ensure that the agency meets its statutory obligations under the NHPA. Section 106 of the NHPA requires federal agencies to consider the effects of federal undertakings on historic properties. The FCC is party to 2 nationwide programmatic agreements that establish Section 106 review rules tailored to new tower construction and co-location projects. These 2 NPAs, I'm sure you're all familiar with them, the NPA for the co-location of wireless antennas, and the NPA regarding the Section 106 National Historic Preservation Act review. Applicants are delegated the responsibility for initiating the Section 106 review process for proposed facilities. The Commission maintains 2 databases, the E106 database system and the Tower Construction Notification System, TCNS, to facilitate communication with relevant parties during that review process. The NHPA and the NPAs require consultation with any federally recognized tribal nation that attaches religious and cultural significance to historic properties that may be affected by an undertaking, and applicants notify tribes of proposed projects using TCNS. My colleague Christine Hico and Jamie Lochinger and Emily Choi from the Advisory Council on Historic Preservation will address these rules in more detail. Jill Springer and Sairi Rajapakse from the Office of Native Affairs and Policy will discuss the FCC's tribal outreach requirements, and Diane Dupert will discuss the ins and outs of TCNS. Next slide, please. Antenna structure registration. Towers that meet certain criteria require notice to the Federal Aviation Administration and ASR notice. These are towers more than 200 feet above ground level and towers that are located near an airport or otherwise create a potential obstruction to air safety. The ASR rules require a tower owner to notify the FAA and receive a final determination of no hazard prior to registration. ASR applicants must complete an environmental notification process unless an exception applies or a waiver is granted. Interested persons may submit a request for further environmental review of a proposed facility in ASR. Again, as a reminder, you'll hear about it a lot today too. Applicants may not begin construction until the ASR process is completed and any environmental concerns are resolved. My colleague Mike Smith will discuss this in further detail. Next slide, please. And our final slide for my presentation, small wireless facilities. The Commission has streamlined its Nhpa and NHPA review process for small wireless facilities. Those facilities generally qualify for Nhpa's categorical exclusions for collocations, subject to certain exceptions. The 2001 Npa for the collocation of wireless antennas, which was most recently amended in 2020, excludes from Section 106 review most small wireless facilities that are not on or near historic properties or historic districts, again subject to certain exceptions. Finally, the Commission has also excluded from Section 106 review the replacement of a utility pole where the pole was not originally constructed for the sole or primary purpose of supporting an antenna for an FCC licensed service. Again, subject to certain exceptions. And my colleagues Sarb Chabra and Paul Dari will discuss this in further detail. And with that, I'll pass it on to Daniela. Thank you, everyone.
Thank you, George. My name is Daniela Reggie. I am an attorney advisor within the Enforcement Bureau's Spectrum Enforcement Division, and I'll be discussing an enforcement overview of the environmental rules. Next slide, please. And here are some examples of Nepa and Nhpa compliance violations. First, we want to highlight the importance of not commencing construction or any ground disturbance prior to completing the environmental review requirements or the FCC's issuance of a finding of no significant impact, commonly referred to as the FONSI, if a FONSI is applicable. Some examples of the applicable environmental requirements include checklists for Nepa and Nhpa, obligations under the Clean Water Act or for wetlands, obligations under the Nhpa that include Section 106 review, tribal review and outreach, or obligations under the Endangered Species Act. For towers that require antenna structure registration, commonly referred to as the ASR, it's important to register the tower prior to commencing construction. Other examples include failure to complete archaeological monitoring during construction, failure to submit an environmental assessment when triggered by the environmental checklist, or failure to complete any required mitigation. And this can include conditions made by the affected state historic preservation officers or tribes. And another important note on tower construction, tower builders and owners are responsible for violations caused by subcontractors and consultants. Next slide, please. Here we've created a diagram to illustrate the three phases of an investigation. The Enforcement Bureau will initially receive a complaint or referral. The Bureau will then conduct an investigation and gather additional information. And after that information is obtained, the Bureau will determine whether to close the investigation or to pursue an enforcement action. And the subsequent slides will detail each of these specific phases in more detail. Next slide, please. Here we're illustrating the sources of Nepa and Nhpa complaints. As you can see, the Wireless Telecommunications Bureau and the Enforcement Bureau receive complaints from a variety of sources. The Wireless Telecommunications Bureau may receive complaints from tribal historic preservation officers, state historic preservation officers, or the public, and then determine whether that information should be referred to the Enforcement Bureau for further action. The Enforcement Bureau may also receive complaints from the public, but it also receives complaints from government referrals, and these can be from various state or federal agencies, from Congress, that may reach out directly to the Enforcement Bureau or to FCC commissioners. The Enforcement Bureau can also initiate investigations sua sponte, and this may result through a news article or another source that may lead the commission to investigate without receiving an informal or formal complaint. Next slide, please. The Enforcement Bureau's Spectrum Enforcement Division will review and investigate a complaint or referral and determine whether it alleges any potential Nepa or Nhpa violations under the Communications Act or the Commission's rules. It's important to note that an Enforcement Bureau investigation is entirely separate from any Wireless Telecommunications Bureau proceeding. Within the Enforcement Bureau, if a violation is found, the Bureau may enter into consent decree with the target of the investigation, or it may issue a notice of apparent liability for forfeiture, commonly referred to as an NAL, or issue a forfeiture order, an FO, with monetary fine. Next slide, please. Now, turning to the second phase of an Enforcement Bureau investigation. A letter of inquiry, commonly referred to as an LOI, is one of the means by which the Enforcement Bureau gathers information. First and foremost, the letter of inquiry, it's a commission order. So recipients must respond timely, truthfully, and completely. Whenever an investigation is warranted, the Enforcement Bureau may issue one or more letters of inquiry to a target. The letter of inquiry will advise of the apparent rule violation or violations at issue, and it will seek information and documents regarding the event, the extent of any harm, and the actions taken by the target. Before filing a response to a letter of inquiry, a recipient must preserve relevant records, conduct any needed internal review, and if necessary, contact the Enforcement Bureau with any questions regarding the letter of inquiry or filing requirements. And when necessary, the Enforcement Bureau may also issue a letter of inquiry to a third party with knowledge of the matter. The Bureau may depose a witness in person, conduct field inspections, or refer any criminal matters to the Department of Justice. Next slide, please. The subsequent slides will address the various enforcement pathways or types of enforcement actions. Some of the key ones here that we're highlighting are a citation, a consent decree, and then the notice of apparent liability for forfeiture or a forfeiture order. A citation is only applicable to some tower owners. So the citation is a warning only to non-licensees, warning them that they are subject to the FCC's rules. A citation is a non-monetary action. In turn, a consent decree is a negotiated settlement agreement between the Commission and the target. It will require a mandatory compliance plan and an admission of liability to the violation. And now turning to the NAL and FO. Both the notice of apparent liability for forfeiture and the forfeiture order details the alleged violations. The NAL will propose a monetary fine, where in turn the forfeiture order will order a monetary fine. Next slide, please. Now turning to the notice of apparent liability for forfeiture. This is a charging document that gives a party notice of the alleged violations. If an investigation reveals a violation of the Communications Act, Commission's rules, a Commission order, the terms of an authorization, the Commission may propose a fine by issuing an NAL. The NAL will provide the target with notice of the alleged violations, the maximum penalty that can be imposed, and provides the target with an opportunity to respond or contest the allegations. So 30 days after the issuance of the NAL, the target must either 1, pay the proposed monetary fine disclosed in the notice of apparent liability, or 2, it may contest the facts and law at issue, but it can also explain why it believes the amount should be reduced. Next slide, please. Now here is an overview of the forfeiture order, because as illustrated, the NAL is a proposed fine, whereas a forfeiture order imposes a monetary fine, and this fine becomes a debt due to the U.S. Treasury. After the issuance of an NAL, the Enforcement Bureau will review any response that's filed from the target. And in the absence of a negotiated settlement through a consent decree, the FCC will generally issue a forfeiture order that imposes the full amount that is proposed in the NAL, but it could also impose a lesser amount, or in rare cases, the FCC may dismiss the NAL. A forfeiture order may be appealed. However, if the target does not pay the fine, the matter is referred to the Department of Justice for collection in federal courts. Next slide, please. And this is the final Enforcement Bureau action, which is a consent decree, which is a common means of resolution amongst the Commission and a target of an investigation. A CD is typically resolved faster with less expense than a notice of apparent liability. It's the settlement of the violation, and it's negotiated between the Commission and the target. Once executed, it terminates the investigation or subsequent forfeiture proceeding. It is important to note, though, however, that a consent decree is generally not available until a party has come into full compliance with our rules and thereby cured any potential violation. A consent decree requires an admission of liability of the violation, and it also typically requires a multi-year compliance plan that's designed to prevent the reoccurrence of the type of violation, as well as a payment of civil penalty. The civil penalty is usually less than that which would be proposed under a notice of apparent liability, because the parties have negotiated a settlement to that effect. Next slide, please. And here I want to turn lastly to best practices. The best way to avoid enforcement actions is to ensure compliance with the environmental rules. And below we've highlighted some best practices. First and foremost, it's important to implement measures to prevent violations, reoccurrences, and ensure compliance in the first instance. And some best practices there are to regularly review and update policies and the applicable Nhpa checklist. It's important to document, authorize, and review each element of a project during each phase of construction. And it's also important to ensure that all employees and subcontractors adhere to Nhpa, Nhpa, or any other applicable procedures that specify the federal requirements, obligations, and timelines. And as stated at the beginning of the presentation, never start construction, including breaking ground, clearing brush, cutting trees, prior to completing the required environmental review. It's also important to notify and actively engage with the state historic preservation officers and the tribal historic preservation officers throughout the process. Applicants should be doing more than minimally following up on an electronic Section 106 notification or responding to inquiries, but they should be actively engaging and communicating with the SHPOs and the tribes throughout the various phases of a project. Applicants and licensees should quickly notify both the Wireless Telecommunications Bureau and the Enforcement Bureau if you suspect a potential violation. The Enforcement Bureau may consider reducing the amount of a fine for a voluntary disclosure, but only if the matter is disclosed directly to the Enforcement Bureau before it begins an investigation. And lastly, I want to stress the importance of responding fully to an Enforcement Bureau letter of inquiry and providing all supporting documentation. As stated in the beginning, a letter of inquiry it's a commission order. Recipients are required to respond timely, truthfully, and completely. Therefore, even if there's no substantive violation, the failure to respond completely can itself result in significant monetary penalties. Next slide, please. So, as a final point, the best way to avoid enforcement is to comply with the environmental rules. We've included here the Enforcement Bureau's contact information, which will direct you to the Spectrum Enforcement Division. It's eb-sed-response@fcc.gov. And that concludes my presentation. Thank you.
Hi, everyone. This is Carrie Hicks. We've received a couple questions during the presentation for George. George, would you please address how RF safety fits into the agency's Nhpa rules? And we also received a question about timing for updating the Commission's RF rules.
Thank you. So let's start with how does it fit with our Nhpa rules. The Commission's rules require Commission applicants to consider radio frequency as part of their Nhpa analysis. For facilities that do not qualify for an exemption under Section 1307B3 of our rules, applicants must prepare an evaluation of human exposure to radio frequency radiation, confirming compliance with the limits in our Section Rule 1.1310. The rules also require mitigation actions to the extent necessary to ensure compliance with the limits and require preparation of an environmental assessment for facilities that will exceed the limits set out in our rules. As to timing, While the Commission's Npa rules require compliance with our RF limits, the limits themselves are subject of a separate proceeding led by another office in the Commission, and we are not in a position to comment on that proceeding today.
Thanks, George. We also see that there was a question about the Nhpa requirements for RDOF. Can you answer that one?
Certainly. The Wireline Competition Bureau manages RDOF, so we recommend you reach out to them about questions relating to RDOF. And we will also be happy to notify them that we have received questions about RDOF in this workshop.
Thank you.
Okay, we have received a couple of enforcement-related questions. For Daniela, are there any incentives for people to identify any non-compliant tower facilities? Or Shannon, I'm sorry.
Shannon, would you like me to address that?
Yeah, please repeat the question.
Certainly. The question is, are there any incentives for people to identify any non-compliant tower facilities? So rather than, I think the question is asking, rather than someone self-reporting a facility as being non-compliant, is there any incentive for someone to identify to the Commission towers that haven't gone through review?
Okay, I think I heard Daniela saying she would take that question.
It's a peculiar question. Incentive for a third party. We appreciate information regarding non-compliance, but if it's the particular applicant or licensee, they should be contacting the Wireless Telecommunications Bureau and the Enforcement Bureau directly. And as it was discussed during the presentation, the Enforcement Bureau may consider reducing the amount of a fine for a target for a voluntary disclosure, but that's only from the target. So if and only if that matter is disclosed directly to the Enforcement Bureau before it's commenced an investigation. Now, for third parties, we would always appreciate information regarding noncompliance with respect to environmental rules and tower construction.
Thank you. There are a couple of additional questions from the same questioner that I'm going to go ahead and answer. The questioner has asked if there is a public database that identifies facilities which have been identified as potentially non-compliant, and the answer is that the FCC does not maintain such a database. And is there a public database which identifies facilities that have been resolved as essentially had compliance issues resolved? And the answer is we also don't maintain that type of database. And I think that is the extent of the questions. We have a couple more minutes if anyone would like to email an additional question. Garnet, we have one more question. This is for either Shannon or Daniela, and the question is, on average, how many consent decrees are issued per year?
I'm not sure that we have an answer to that number, but all of our enforcement actions are available on our public-facing website. So you can just go onto the Enforcement Bureau webpage and click on Enforcement Actions, and you can filter through consent decrees or any other type of enforcement action, and you can see how many have been issued in the last year or years past.
And one more enforcement question. What are some of the most common violations that the Enforcement Bureau sees?
Daniela, feel free to supplement this question, but
I think like a key point there is, I don't think we've created a database of ranking, but as it's highlighted in this workshop, in this section, and our first speaking points, it's important to ensure that you're complying with the rules in the first instance. So it's important to ensure that you have completed all the environmental review requirements prior to commencing construction. I think it's really essential that there's some due diligence before the project kicks off to ensure that all the obligations under Nepa, Nhpa, or any other applicable environmental rule and statute are addressed.
And I just wanted to add to that Daniela covered some examples of some violations under Nepa and Nhpa in the first slide.
Okay, and we're going to take one final question, and I'm actually going to direct this to Garnet. The question is there any movement or update on the Twilight Towers issue?
No.
Thank you.
Nothing further to add. Where's Jamie? Okay, I think that's it. Thank you, Daniela, George, and Shannon. Thank you very much. Very interesting, and yep. Okay, before we start our next panel, I believe we did get some questions about whether or not the slides are going to be available. Just to reiterate to everyone, we are recording this workshop, and so both the slides and the recording will be available after today and will be on our website. So in case you missed anything or we're going too fast with the slides and you want to take notes, they're going to be available for you. Okay? Thank you. Okay. Our next presentation will focus on Section 106 review of wireless facilities. I'd like to introduce Christine Heacock, the FCC's Deputy Preservation Officer, and I'm also thrilled to introduce our guest, Jamie Lossinger, Assistant Director of the Advisory Council on Historic Preservation, and Emily Choi, Historic Preservation Specialist of the Advisory Council on Historic Preservation. Christine and Jamie are presenting in person, and Emily will present virtually. Christine, I'm going to hand it over to you. Thank you.
All right, thank you, Garnet. So as Garnet mentioned, we'll be doing an overview of the Section 106 review process for wireless facilities. Next slide. So in this session, we'll give a general overview of the Section 106 process to include an introduction to our nationwide programmatic agreements, effect findings, the memorandum of agreement process, and the electronic tools used to complete Section 106 for FCC undertakings. Jamie will speak for the Advisory Council, their general role in Section 106, Section 106 in infrastructure projects, and involvement in FCC undertakings. Next slide, please. So environmental compliance. So it is important to note that the FCC licenses spectrum for non-federal uses, which includes consumer and commercial use, as well as state and local government. The FCC does not issue licenses for towers. Geographic area license holders determine the locations of towers in order to meet their coverage objectives, and licensees must comply with the FCC's environmental rules, which implement the National Environmental Policy Act, or NEPA. You'll hear more about that this afternoon, and George spoke about it earlier, and as well as the National Historic Preservation Act. And as a federal agency, the FCC is responsible for ensuring that its actions and undertakings comply with all applicable environmental laws and regulations. Next slide, please. So, Section 106 of the National Historic Preservation Act, it created the National Register of Historic Places, the Advisory Council, and requires that each agency develops a historic preservation program and employs a federal preservation officer. It requires federal agencies to consider the effect of their undertakings on National Register Historic of places eligible and listed properties. So when we say historic properties, that's what we mean, eligible for listing or listed on the National Register. And under the NHPA, an undertaking includes projects, quote, requiring a federal permit, license, or approval, end quote. Due to its relation to licensing and antenna structure registration, the FCC has treats tower construction as an undertaking. Next slide, please. So the ACHP's rules allow for program alternatives to create historic preservation review processes specific to an agency's undertakings. So in August of 2000, the Advisory Council established a telecommunications working group to develop a streamlined Section 106 review process for wireless facilities. And as a result, the Commission has entered into 2 nationwide programmatic agreements with the Advisory Council and the National Conference of State Historic Preservation Officers. And these streamlined review requirements of the co-location MPA of 2001 as amended, and the Wireless Facilities MPA of 2005 establishes an applicant's Section 106 obligations under our environmental rules. Next slide, please. So the Section 106 process. So the Wireless Facilities MPA, or if you've interface with Jill and I, when we say the NPA, this is what we mean, defines an applicant to include commission licensees, permittees, or registration holders, applicants or prospective applicants for wireless or broadcast licenses, authorizations or ASR, and their duly authorized agents, employees, and contractors. FCC rules delegate Section 106 obligations to applicants who in turn follow the requirements outlined in the NPAs. And in 2000, the Advisory Council signed a delegation letter which allows applicants to act on behalf of the FCC in the Section 106 process. This includes initiating review and preparing and distributing reports and findings to SHPOs, tribes, and consulting parties prior to construction. Next slide, please. As the previous session mentioned, an applicant violates the FCC's environmental rules if it begins constructing a facility before ascertaining whether the facility may have a significant environmental impact by completing the Section 106 and reviewing the Nepa checklist. This includes clearing soil or vegetation, disturbing ground, and digging. The Competition and Infrastructure Policy Division is the first line of environmental compliance review, and although the Enforcement Bureau is primarily responsible for enforcement of provisions of the Communications Act, the Commission's rules, orders, and various licensing terms and conditions, the Wireless Telecommunications Bureau does have concurrent jurisdiction with the Enforcement Bureau over environmental enforcement. Next slide, please. So general NPA provisions. The NPAs do not apply on tribal lands unless a Tribal Historic Preservation Officer, or THPO, or tribal government agrees. NPAs do not apply on federal lands, but land managing agencies may avail themselves of similar rules by following the Broadband on Federal Lands Program comment. And you will hear this several times in this presentation. The NPAs encourage applicants to hire the appropriate Secretary of Interior qualified professionals to support Section 106 review. This is important because these qualifications allow for applicants to more accurately assess the effects of these proposed undertakings on historic properties. To assist the Section 106 process, the FCC employs a Federal Preservation Officer, so Jill Springer, and a Deputy Federal Preservation Officer, myself. We become involved in these reviews when potential adverse effects are identified, to resolve disputes, or at the request of a tribe. Next slide, please. So the 2001 co-location MPA, I will do a quick overview. There will be more information on co-locations in the presentation on small wireless facilities. Most antennas placed, so this establishes that most antennas placed on existing towers are excluded from routine Section 106 review. Co-locations on towers constructed before March 16, 2001, they are ordinarily excluded provided that the antenna will not substantially the tower size and the tower has no pending complaints or unresolved adverse effects. And co-location on towers constructed after March 16, 2001 are excluded provided that the tower completed Section 106 review prior to construction, the antenna will not substantially increase the tower size, and the tower has no pending complaints or unresolved adverse effects. Next slide. So as we mentioned before, the co-location MPA has undergone a couple of amendments. The first amendment occurred in 2016 and expanded on the exclusions permitted. These included co-locations on and in buildings and structures that are not historic or in or near historic districts, co-locations on or in buildings or structures that are historic or in or near historic districts that are not National Historic Landmarks that meet size and visibility limitations and require no new ground disturbance, co-locations on utility poles or transmission towers in or near historic districts that meet size and visibility limitations and require no new ground disturbance. And last, co-locations on lighting structures that the SHPO agrees are non-contributing elements within a historic district. Next slide. And then the co-location NPA was most recently amended in 2020. It eliminates Section 106 review for certain co-locations that involve limited expansion beyond the boundaries of the tower site, and this specifically revises the definition of substantial increase in side to be consistent with its use in the NPA. And as a result, the co-locations that, quote, do not expand the boundaries of the current tower site by more than 30 feet in any direction or involve excavation outside these expanded boundaries may qualify for a Section 106 exclusions, provided they adhere to other applicable size and equipment limitations. Next slide, please. Okay, so the NPA, as I mentioned before. So applicants, so this applies to the construction and modification of facilities, which can be either towers or antennas, and towers are defined as structures built for the sole or primary purpose of supporting licensed or authorized antennas and associated fencing, equipment, cabling, switches, power, and shelters. Definitions of these terms can be found in Section 2 of the NPA. The NPA excludes tower enhancement, replacement, and temporary towers. It also excludes towers in industrial parks, malls, and communications or utility rights-of-ways, provided the site is not in or near historic properties. Exclusions can be found in Section 3 of the NPA. And lastly, it clarifies roles of applicants, SHPOs, and the consulting parties, and establishes tribal outreach requirements. Next slide. So general overview of Section 106. So the SHPO has 30 days to concur or comment on an applicant's submittal. So this is done through a Form 620, which are for new towers, and Form 621 for co-locations. A concurrence on no historic properties affected or no adverse effect on historic properties concludes the Section 106 review once tribal consultation is complete. In cases where there is a finding of no adverse effect on historic properties, filings can be submitted to the Commission by emailing the DFPO, myself, and concurrently submitting a referral in the E106 system. This is described in 7C2 of the NPA, and the Section 106 review process is then complete unless otherwise notified by the Commission within 15 days. And if the SHPO does not concur with the effect finding made by the applicant, or there's an adverse effect finding, consultation continues. Next slide, please. Okay, conditional, no adverse effect. So revisions in 1992 to the Advisory Council's regulations and also the FCC rules permit the conditional no adverse effect, and it allows the SHPOs to condition their recommendation for a no adverse effect by requesting that the applicant take certain steps to reduce or eliminate this effect. The use of this option does not trigger a memorandum of agreement or MOA, and it require that the applicant file an environmental assessment. Next slide. So an adverse effect. So when an applicant determines that a project will have an adverse effect and the SHPO or the TIPO concurs, then they must notify the Advisory Council and the FCC. Although the Advisory Council does not always participate, they do need to be invited, and the applicant is responsible for submitting this documentation and the request for them to participate in the to the Advisory Council on behalf of the FCC. An adverse effect does not stop a project, and to go forward, the applicant must submit the alternatives analysis and a mitigation plan. But if the Form 620 or 621 identifies an adverse effect, these two elements must be included in the original documentation. So if an applicant in their initial findings sees that there's an adverse effect, that has to be in the original submission packet. However, if it's the results of the SHPO or another party, if it comes up that there's an adverse effect identified, then that can be submitted later. But if it's done by the applicant, that has to be originally submitted. Next slide. An alternatives analysis. So this demonstrates to the SHPO, the TIPO, and the FCC, as well as consulting parties, that the applicants considered other sites. This must provide maps and show these other sites that were considered, and provide a narrative that explains the reason for this particular site. And the applicant may, of course, request that any proprietary information is restricted to the FCC. Next slide. So mitigation suggestions. So there are a few things that applicants can do to minimize adverse effects. This includes lowering the height of the tower, reducing the size of communication gear. You can paint to match the surrounding environment or any of the gear, install a stealth tower. I think the most popular example I can think of is when you're driving down the road and you see one of these pine trees, one does not quite look like the other ones. That's a monopine. That's a good example of stealthing. You could also do plantings, so these can be examples of people doing plantings around equipment to kind of conceal it, or folks can do plantings that will lightly draw and help conceal the equipment, or you can provide a benefit to an affected historic property. Next slide. So this mitigation option includes updating a National Register nomination, commissioning a Historic American Building Survey, HABs, or Historic American Engineering Record, HARE documentation. You could develop and install wayfinding signs or historic markers, prepare a brochure, develop a cell phone tour, which might be useful. You're about to have a tower there, might have great reception. A cell phone tour might be helpful. And work with the SHPO and local community to identify any historic preservation needs. Next slide. So the MOA. So applicants should negotiate with the SHPO, the TIPO, and consulting parties on the stipulations for mitigation. So those are all the things that we just went over, all these options for helping offset this adverse effect. The applicant should prepare the MOA following the FCC template, which is available on our website. And draft MOA should be sent to s106.moa@fcc.gov for commission review. And this is after the parties have negotiated their mitigation strategy. So when we receive the draft MOA, it's with the knowledge that all the parties have agreed to these measures. Most MOAs do not require that all of the mitigation measures be completed prior to construction, and the MOA should include a reporting requirement to notify all of the signatories that the mitigation measures have been complete. Next slide. So the Fcc Mpa Electronic Tools. So as mentioned before, we have two databases. There's the Tower Construction Notification System, which is a voluntary system developed to facilitate tribal Section 106 participation. Tribes and Native Hawaiian organizations designate geographic areas of interest, and the FCC protects this information as confidential. Project information supplied by the applicant is automatically forwarded to interested tribes, and tribes may respond if they're interested in further participation. It's important to note that TCNS simply provides notification. It does not substitute for the Section 106 process or government-to-government consultation unless a tribe disclaims interest. Next slide. Another electronic tool is the E106 system, and up there you can see the link for that. It's the electronic database used to file FCC forms supporting MPA reviews, and as we've said, Form 620 and Form 621, submission packets, and the applicants can refer non-responsive SHPOs or tribes to the FCC for follow-up. Next slide. So some pro tips, as I had mentioned before, when there's a no adverse effect determination, it can be sent to the FCC, and that's my email address, so I see a lot of these. So the FCC, again, Form 620 is prepared for new towers, and the Form 621 is for co-locations. If you follow the instructions found in the Section 106 Tools section at the following website, it's the Tower and Antenna Siting site. This can be your best friend for completing Section 106 that has a wealth of information. There are even documents that will walk you through filling out the Form 620 and 621. And the procedures are detailed in Section 7 of the Npa. And the Npa encourages, again, the use of Secretary of the Interior qualified professionals to identify historic properties within the area of potential effect. Next slide. And another group of tips, please ensure that the fields in the submission package all the fields are filled out. And again, please use the properly qualified individuals to make these determinations of effects and identify historic properties. And these form instructions that I previously mentioned do include photographic standards for the submission packets. And captures from Google Street View are not adequate to meet these requirements. A lot of times they're outdated, or they don't provide, or they're outdated, or they don't provide for the correct vantage point for a reviewer to get a full sense of what is being proposed. And with that, I will hand it over to Jamie.
This is all so very formal. The ACHP is way more casual, so I'm not used to microphones and cameras and technology that actually works. I'm Jamie Leuschinger. I'm with the Advisory Council on Historic Preservation. Emily and I are both really happy to be here today. I think the last time might have been either 2018 or 2019. I was brand new in my role then. Emily has come on since that time, so it's nice to meet all of you and hopefully put a little bit of information behind who the ACHP is. I think a lot of people maybe don't know who we are. So we can go to the next slide, please. Some of this was touched on already, but the general role of the ACHP in Section 106, our primary responsibility is to promulgate the regulations that implement Section 106, 36 CFR Part 800. They were referred to as our rules, but I would go ahead and posit that they're actually everybody's rules. You know, the Section 106 regulations are for every federal agency unless they have an approved program alternative. So we'll talk about, obviously, how FCC has a few of those already in the books. So that's how they meet their compliance responsibilities. The Nhpa was not the first preservation law here in the United States. There were plenty before. 1901 was the American Antiquities Act. It might have been 1906. 1935, Historic Sites Act. But in 1966, post-World War II, you have this huge boom of building, and the interstate highway system is being built. And all of these historic properties were being lost. Some of you might even think about Penn Station up in New York, a watershed case that kind of led Congress to start thinking about how do we balance the needs of a growing nation with wanting to preserve something for the next generation. And from this, the National Historic Preservation Act is born. So it created the ACHP, who again created the Section 106 regulations. It created the State Historic Preservation Program. It created the Tribal Historic Preservation Program. It specifically calls out the special expertise that tribes have in identifying historic properties of religious and cultural significance and affirms that very positively for federal agencies. The National Register of Historic Places is established as well, and that's kind of the baseline that we then use in Section 106. One of the other primary roles of the ACHP is to advise the President and Congress on how to use our nation's diverse historic resources. A lot of the time we do that through overseeing the Section 106 review. Section 106 is the meat and potatoes, quite frankly, of the agency. It's what we spend the most time doing. But we also do a lot of other policy roles. We look at how do we advise agencies on integrating things like climate change into historic preservation reviews. How do you incorporate environmental justice into historic preservation reviews under Section 106? We've also looked at issues of digital information. How do you make information about historic properties more widely available in a way that also respects confidentiality, proprietary business information, and so on? One of our newest ones is climate change. We're spending a lot of time there, as you can imagine. Also, workforce development. Christine's mentioned a few times the use of qualified professionals. We're running out of them. So we're looking at, how do we get people interested in this field? How do you kind of foster that interest and carry it through, undergrad, graduate school, professional development? How do you make that happen, and Also, do you get people to work for the federal government? We're running low. The office that Emily and I are in is the Office of Federal Agency Programs. We're the biggest office in the ACHP. About half of our 40-person staff is in OFAP, as we call it. Other offices are the Office of Preservation Initiatives, our Office of Native American Affairs. We have a very active Office of General Counsel. So, and those all support the work that we do in OFAP through Section 106. Those 40 staffers that Emily and I are part of, we support the work of the 24 statutorily designated members of the council itself. The council is comprised of a lot of different folks that represent different interests in historic preservation. So it's not just federal. We look at having members that represent the interest of local governments, state governments, tribal governments, Native Hawaiian interests. We have expert members that are archaeologists or urban planners. Actually, one of our members right now is a planner. And then, of course, we do have some ex officio members, like the National Trust for Historic Preservation. The Architect of the Capitol is one of our permanent members. So, again, representing a huge range of interests. They're the ones who really would be reporting out to the President and Congress. It's not generally happening at a staff level. And they meet 3 times a year to discuss not just Section 106, but these broader policy issues. Our next meeting is actually at the end of October, and it's a jam-packed agenda, and you all should tune in. I'll tell you that much. We're going to be discussing 2 new program alternatives, actually, that'll be coming to the membership for a vote. A program comment on Vietnam War-era housing, which is impossible to say, from the Department of Army. And then actually we're considering an exemption for the installation of electric vehicle supply equipment across the country. So I've gotten a real education in EV and telecommunications in the last few years. So we'll go ahead and go to the next slide. This has been touched on quite a bit already. Christine's presentation really gave you way more information than we'll go over here today. There are the 2 nationwide PAs that provide a tailored approach to Section 106 for FCC and its applicants. So it lays out the process to identify historic properties, to assess effects to them. What does that consultation process look like throughout the way? There's also the 2 program comments. One was mentioned earlier, the program comment for wireless facilities on federal land, and then there's the other one that allows certain other applicant-based agencies to also utilize some of the FCC's procedures. So we'll go ahead and go to the next slide. Probably one of the biggest questions the ACHP has asked, we're somewhat seen as a subject matter expert here in tribal consultation. Again, our expertise is going to be related to tribal consultation within the Section 106 process. There's a lot of other tribal consultation that happens in other environmental reviews. As you all probably are aware, the federal government does have a unique legal relationship with federally recognized tribes. That relationship is spelled out in the Constitution, Supreme Court decisions, treaties, several executive orders. It recognizes the trust relationship that the federal government has, but also the government-to-government relationship that exists. That federally recognized tribes are essentially dependent sovereign nations, and that should be recognized in these environmental reviews. So we have a coordination handbook that you'll see the title of it on the screen here, Early Coordination with Indian Tribes During Pre-Application Processes, a handbook. So you can go there and take a look at that. We also have an online training course that goes along with that talks about coordination with tribes for infrastructure projects. You can also find more information on our website that's listed here. Obviously, that's a unique relationship for FCC, to play, but you all as applicants or as consultants play a role in making sure that that happens too. So we can go to the next slide. We've covered a lot on broadband in Section 106. I think this is one of the sectors that the ACHP considers the most broadly covered by program alternatives. We've spent a lot of time and effort with FCC making sure that there's an appropriate process that fits FCC's needs when it comes to broadband. We're also a member of the Federal Permitting Improvement Steering Council. It's quite frankly, I try to stay away. I defer to our expert within the office on that because it's a lot of other acronyms that I just don't know how to learn. So I focus my efforts on the broadband work group, making sure that, any of the discussions there recognize the efficiencies that have already been created, making sure that there's a clear understanding of what Section 106 is how it's defined, how it's met, how agencies can utilize the existing program alternatives. Our website there that's listed on the screen, broadband and Section 106 lays out a lot of those efforts as well. One of the things, I'll just point out, the Federal Permitting Improvement Steering Council, FIPSI is what it's known as, if you're going to pronounce the acronym that way. They required the development of a permitting action plan recently that's currently being reviewed. It's kind of an interesting thing. The ACHP really is in an oversight role, a regulatory oversight role. We don't ourselves permit actions, but so our plan really focuses on how are we helping agencies effectively and efficiently permit, license, approve, provide funding for a variety of projects. So we can go to the next slide now. And with this, actually, I will go ahead and turn it over to Emily, who's joining us virtually.
Hello, everyone. My name is Emily Choi. It's great to be here, albeit virtually. I'm a historic preservation specialist at the ACHP, and I review submissions from FCC along with about 7 or 8 other agencies. And I'll begin with a very brief overview on what is the ACHP's role in the Section 106 process, and more specifically, when does ACHP participate? So for a given undertaking, if one or more of the Appendix A criteria apply, then ACHP can exercise its discretion to participate in consultation. So the criteria, which are listed on the slide, and you can also find them at the end of our regulations, 36 CFR Part 800, the undertaking has substantial impacts on important properties, it presents important questions of policy or interpretation, it has potential for procedural problems, or it presents issues of concern to Indian tribes or Native Hawaiian organizations. So when it comes to FCC undertakings, for the last 3 years that I've been here, we're seeing a higher than 90% no participation rate. And this is mostly because I think the Appendix A criteria almost never apply. The most common adverse effect I see, in fact, the most common adverse effect I see, in fact, I'd say this is the most common, it's about higher than 90% rate of occurrence of this effect as well, would be visual impacts, either of or from a historic district. So since these types of effects are being mitigated so routinely, consistently, and well, the associated undertaking doesn't meet any of our criteria for participation. I will say, though, even though we don't formally participate, we provide a lot of technical assistance to applicants, to SHPOs, and various local consulting parties, such as municipal governments, nonprofit or interest organizations, and also interested individuals. So in these latter circumstances of technical assistance, particularly with the local parties, there's one thing I've consistently heard and observed, and that would be the need for more flexibility as to the location of structures. So keep in mind, I think, the advancements of technology since the NPAs were executed, as well as the need to balance the public interests of infrastructure and historic preservation. It would be the ACHP's advisory opinion that building in more flexibility, particularly when requests are timely, specific, and consistent with the purposes of the NHPA, additional flexibility would result in the best kind of outcomes under Section 106. And so in closing, I'd like to emphasize 106 really isn't a solicitation of written comments. It's set up as an iterative process by the statute as well as the regulations. It's really meant to be a series of back and forth, which really identifies common ground and makes forward progress towards, ideally, consensus. So as you navigate 106 consultation, please reach out to us with questions or concerns. I respond to all of my emails as quickly as possible. I know Jamie's good with email too, although she maybe doesn't want me telling you that. But of course, you should also consider reaching out to the FCC or the appropriate SHPO, as they also have quite a bit of experience in these areas. So thank you.
Thank you, Emily. I'll just emphasize a few points there, too. I think Emily is spot on, especially that last part about it being an iterative process. I know that the tower construction notification system, it has notification right in the name. But again, this is really meant to be a dialogue. If you look at the definition of consultation in the regulations, it actually says it's this active process of seeking and discussing and considering the views of other, and where feasible, seeking consensus, finding that consensus. It's not always possible. We recognize that. There are frequently disputes about how do you meaningfully resolve an adverse effect? Is there really an adverse effect? Does it rise to that level? But those are disagreements. We can get through them. It'll be fine. That's what the ACHP is also here for. But you also have two excellent preservation officers here within your agency that are also well equipped to assist in resolving those disputes. So. A couple of other notes that I made just along the way from Christine's presentation, just that don't really fit into any of our slides, but just thought I would throw out there. In addition to HABs and HAIR, there's also HALS, the Historic American Landscape Survey. That's something that we're seeing a little bit more out west being used as a mitigation measure to recognize, how these landscapes might actually also be considered historic properties under Section 106. So I would encourage you to think about that possibly as a mitigation measure where appropriate. Conditional no adverse effects give me heartburn. It has to be said. Yes, under an earlier set of our regulations, a conditional no adverse effect was specifically called out as a potential finding. We got really clever in the 1999 amendments and the 2004 changes to where we called it now a no adverse effect with conditions, just flipping it the other way. It's still a finding. It's still out there. You should still use it as appropriate. I would just caution you as a word of advice. If your conditions are starting to look like mitigation measures, just call it an adverse effect and write an MOA. That's where I think that line gets a little bit blurry sometimes. So there have been a few of those, not with FCC, but those have come in from other agencies of late that I'm like, if you spent this much time negotiating these conditions, why not just throw a few whereas clauses ahead of it and sign on that last page? So just some advice there. And then last but not least, the template MOA that FCC has is an excellent starting point. I would remind you it is a starting point. The template agreement is not an officially designated program alternative, if you will, under Section 106. So that is something. Some SHPOs may want to change some of that language. I'm not saying that all of those changes are always, going to be agreed upon. It's just, again, I would recognize that some of that language can be altered, again, in consultation with FCC and other consulting parties to get to what will work for everyone. So just worth a reminder there, too. And I guess now we're in the hot seat for questions.
So we actually have received a lot of questions.
Oh, boy.
And that was before the last things you said, Jamie, so I'm expecting a few more questions.
All right, here we go.
So Ms. Heacock mentioned historic properties as being eligible or listed in the National Register of Historic Properties. What about state-recognized historic properties that have not been determined eligible for the NRHP?
So this is why we encourage SHPOs and their records to please formally, determine eligibility for the National Register in their record, so applicants can consider these. You can definitely, it's okay to bring it up, but the definition is nationally eligible for the National Register of Historic Places.
So I would just add one small thing to that answer, which is to say that there is a provision in the NPA that allows a SHPO in responding to an effect finding to request the consideration of a property and let the applicant know that they consider it to be National Register eligible. So that's something to keep in mind. So the next question is, when a memorandum of agreement is completed, which parties retain or track its existence? And I think this goes equally to Jamie and Emily and to Christine.
So I'll just start. So for our process, so when you go through the MOA process, so there's an adverse effect. Everybody agrees on mitigation measures. We make the edits. All the parties sign. The FCC is the last to sign an MOA, and then in turn, the FCC will send the fully executed MOA to the consultant, usually, who's working on behalf of the applicant. We'll remind you that applicants are responsible for retaining records of Section 106 compliance. The FCC also keeps a record, and then when an MOA is executed, the FCC then sends it to the Advisory Council for their records as well.
And we do keep copies of all executed agreement documents. So that is one of the things that under the regulations and also your NPAs, you are required to file those with us. That's one of the other parts of completing Section 106 is filing it with the ACHP and then actually implementing all of its terms. You can't get out of implementing the terms. So if there's ever a question about, is an agreement available, we can certainly look for it. It's somewhat going to come down to, do we have it electronically? One, I don't want to call it a side benefit of the pandemic, but has been like, now we actually are doing things electronically. We're not using all of the paper files, which is kind of nice. It makes it a little bit easier. If somebody does have a question, we can very quickly go into our database and say, here it is, if somebody has any questions. So.
Okay, Jamie, if a SHPO and/or TIPO concurs with an applicant's no adverse effect finding, but a local government does not, is Section 106 complete, or does it continue with the adverse effect mitigation process ending in an MOA?
So in the regulations, if an agency, or in this case an applicant, is making a finding of no adverse effect, but a consulting party disagrees or disputes it, then the option is to continue consultation to try to resolve the dispute. I would recommend bringing FCC into that conversation, to see if that can be assisted, if that would help kind of break up the logjam. If, again, that doesn't work, then the option is to come to the ACHP. We can review disputed effect findings. We provide our advisory comments to the agency and to the consulting parties about how we think the dispute might be resolved. And sometimes that'll run the gamut of really what our advice will look like. It's really tailored to the undertaking, to the historic properties, to the level of consultation that has been done. And we also look at how well, in this case, the terms of the NPA have been applied, or, have you appropriately applied the criteria of adverse effect? We might offer some suggestions there too, and then the agency has the responsibility to consider our comments and either, in responding to them, either reaffirm their finding, or we have a less than stellar success rate of convincing people to change their findings and maybe go on to the next step of consultation. But the ACHP is available to assist in those kinds of dispute situations.
That's great. And one thing I would add that's specific to our NPA, so Section 5 of our NPA addresses local government involvement and also public participation. And if an applicant or a consultant working on behalf of an applicant gets comments either from the public or from the local government, they need to provide those comments to the SHPO, because the SHPO should have an opportunity to take that into account in rendering their opinion on the project as well. Ms. Heacock, regarding the advice not to use Google Street View, in some cases, archaeological survey is not required. So under the NPA, the applicant is restricted, their obligation is restricted to doing archival research. In a case like that, is it acceptable to provide a Google Street View image with the Form 620 or 621 where no field work was done or required?
I mean, so there are cases where there is no field work required, but in terms of meeting the photographic requirements set forth in the NPA, we would prefer to not use Google Street View. I know people do use it, but there's still a photographic requirement, so you may not have to actually go out and dig or do a field visit, but it is good to actually have someone on the ground that can see the real world conditions of a proposed facility. I've seen in some of these things that are submitted, you look, because it does happen, that's why we're bringing it up, and you know, and you look down, and it is obviously one of those cases, but then you look down at the image and it says like 2019, and then nothing's like it was in 2019. So in those cases, it doesn't meet there may not be the fieldwork requirement, but if there is still a photographic, you know, there's the photographic requirement, we would still want you to meet those parameters that we set forth in the Npa.
So that's a really great point. Some of the newer consultants who are coming online, and even some of the folks who've been doing this for a while, don't go back to the instructions that do come with the Form 620 and Form 621. You can still find these instructions on our website in PDF form. And what Christine is referencing is there is a section that tells you specific views that are expected to be within that Form 620. So. You know, it wouldn't necessarily require a cultural resource person to go to the site if fieldwork is not otherwise required. If there is a project manager or someone who's there who can take the directional photographs in following those instructions, that would be very helpful to all the parties that are involved. Good point. So one of the things that I see is that we have several questions that are coming in about tribal participation, which is great. I want to make sure that everyone is aware that we have a couple of sessions that are coming up. One is coming up at 1:15 on tribal participation under the Nationwide Programmatic Agreement. We have another session that's coming up specific to using the tower construction notification system. But a specific question that was raised is if TCNS is voluntary and does not substitute for government-to-government consultation, how does the FCC consult with tribes to identify historic properties, especially if a tribe doesn't use TCNS? How does the FCC and the applicant consider how properties of religious and cultural significance to tribes may be affected? So I would just say that we're going to cover that in a lot of detail at 1:15. And then I would also mention that we're fortunate in the sense that TCNS is a pretty unique system, and we do have participation by all the federally recognized tribes. So we do have contacts for all of the tribes, and we maintain great support for the TCNS system and are in contact through TCNS Help and also just directly. So those are two things that we'll be talking about a lot later in the day. You'll also hear from a representative of our Office of Native Affairs and Policy, and that is the entity, the office in the commission that actually is responsible for large G government to, or large C consultation, government to government consultation. So we'll be talking about that a little bit more. Another question came in as to whether there was any way an applicant can determine if a TIPO or tribal government has agreed to follow the NPAs. Christine pointed out in her presentation that the NPAs don't apply on tribal lands unless a tribal government has agreed to follow them. And the answer is that we don't maintain a database on that, and it really is a situation where you need to reach out to the TIPO to determine if they're going to follow it. And also that, that can be a decision because the tribes aren't signatories to the NPAs. They can kind of make that decision on a case-by-case basis. So again, it's not a binary thing that they're going to follow it or not necessarily, and we don't right now have any database that indicates which tribes have determined that they will follow it. We also have a question that has come in about wireless facilities that are located on federal property. And we have another session at the end of the day today about streamlining multi-agency environmental reviews for broadband projects that I think that will be very helpful because like many things in our rules, there are a lot of nuances that are involved when a facility is proposed on federal lands. I mean, one of the one of the nuances is whether or not it's a facility that's supporting government use, which might deal with spectrum that the NTIA regulates, that the FCC doesn't regulate. So NTIA will be joining us this afternoon. There also are other considerations with, in some cases, we have a session this afternoon that is focusing on antenna structure registration. And when antenna structure registration is required, there is an environmental notification that's triggered under our rules that would kind of work in coordination with Nhpa, but it's a separate requirement as well. So I very much encourage the folks who are interested in knowing about deployments on federal lands to join us this afternoon, and we'll go into that in detail. So we've just gotten a follow-up Google Earth photo question.
I knew this was going to happen.
That I will direct to Christine. Given that part of the reason that Google Earth images are not preferred is that they may be outdated, is there any age requirement for in-person photos to have been taken to avoid their also being considered outdated?
So we don't have I don't know that there's an age requirement. I mean, in those Section 106 tools on the tower antenna sighting page, it does have the requirements. I mean, obviously, by the time we're reviewing it, or if it's at that stage of review, it's not, that day. But I don't know of a time. Just, my advice would be when you're putting your submission packet together and you're trying to make these determinations of effect and identify historic properties, that would be the time to do it, is when you're putting together the submission packet, because that's, there may be times where, a project may take longer, so there's an adverse effect or whatever, but we know at the time that it was around the time that the packet was compiled, like these are photographs to that time. You're trying to document basically the current site conditions of the proposed undertaking.
I wasn't going to jump in on the Google Street question, but I would point out, that question of timeliness of information, how accurate is that information? Is it still valid? That comes up a lot, I think, when it comes to looking at archaeological survey reports or even historic property survey reports. Does that information still hold? And there is, we, in our regulations, caught myself. In the Section 106 regulations, there's kind of that requirement, or at least we say to agencies, look at whether that information is still valid. It's not necessarily because it's 20 years old that it's no longer automatically not able to be considered, but rather there's been a lot of technology changes in the last 20 years, and there may have been properties that weren't included in that original survey that have now become historically significant or could be considered historic. Maybe some of those old archaeological surveys were done with outdated methods. Maybe they didn't take into account the views of tribes or Native Hawaiian organizations. So if there are those kinds of data gaps, then we do recommend in a Section 106 review that you go back and fill them. That you don't start from scratch. You still use those reports. You just fill in where the blanks may be. So, not the Google Street issue, but just general timeliness in 106.
But I do have a follow-up Google Earth image question for Christine. May Google Earth images be used to supplement in-person photos?
No. That's the whole point, is they should not be used to supplement in-person photos. There's the issue not only of timeliness, but also vantage points. I mean, it's Google Street View, so where this facility might be, the Google cameras may not have had access to where you need to actually have been to create that, for certain cases, a 360 view of the proposed facility. So no, I'm sorry. I know people like to use it, but it just does not meet the requirements. I can kind of understand that. I will say I've seen those, and I cringe a little less. But
Christine, I just want to jump in and repeat the question for the folks who are
Yes.
watching and might not have been able to hear this, because this is another reason why we wanted to try to do the questions this way. And that the question was, there are instances where it may not be safe to take a photo from a specific vantage point, and is it acceptable to use Google Earth as a supplement in those cases?
I don't know, in this one, I mean, proposing Jill, I might tag you on this as well, but I mean, in a lot of cases, I mean, to assess effects, in most cases, there should be a place where you can safely go to take photos, but
Yeah, I think probably to draw this to a close, what I would say is, I don't think that we're going to say that you can't use anything. The most important thing is that you need to convey to the parties who are reviewing the property what the conditions are. And if, you know, from our experience, we have some skepticism, because remember, the FCC is called in if there's a dispute or if there's a challenge to something. And it's difficult for us, if we are in that situation, to be faced with a Google Street View thing that we can't be certain that it represents the actual condition. So what we're asking you to do is follow the rules in the Form 620 instructions, take the views that that discusses, and just make sure that for all parties involved, you can convey what the actual situation and the potential for effects is. And that, I think, is fine. And we'll deal with it if it involves a Google Street View. We have one final question, and then people might have a moment just to stretch their legs here before we transition into the next session. Is there a reporting requirement for the demolition or decommission of a tower site? For instance, returning the ground to its natural state. I'm going to ask Christine to talk about this specifically in the context of the MOAs, because it is a provision that's in our MOAs. But I do want to mention that we do have an antenna structure registration session later in the day, and there may be implications that we can get in, you know, in that. We're only going to be answering in the context of Section 106 right now. Sorry.
Yeah. So there is a provision in the MOAs to return the site back to its back to the conditions prior to construction.
Okay, and we have some supplementary information.
So for towers that do require registration in the antenna structure registration system, so those are towers that are 200 feet or more or within a flight path. If they're registered in ASR, you are required to file a dismantlement notification within 5 days of dismantling the tower. So we and the FAA are aware of any dismantlement of a tower.
So that concludes the questions that we have right now. And thank you to Christine and to Jamie for that great presentation. People continue to ask, will these decks be available? They will be available with the recording of the event on the events page in the future. And we will resume at 11:45 if everybody wants to take a quick break.
I'd also just add thank you to Emily Choi for joining virtually. She is really your primary point of contact. echoi@achp.gov. I am good with my email. Emily is better. Thank you.
Yeah, I apologize, Emily. I'm not used to this virtual format, so that was all on me.
No worries at all. Thank you, Jill.
Excuse me, everyone, it's time to resume. I know it's great to see people in person and have discussions, but we really do have a lot to cover today, so thank you again. Okay, so we are on to our next panel. Our next presentation will focus on small wireless facilities, which will be presented virtually. I'd like to introduce Saurabh Chhabra, Senior Electronics Engineer, and Paul Dari, Senior Counsel, both of which are from the Competition and Infrastructure Policy Division within the Wireless Bureau. Okay, we're going to do this virtually. And I think I hand it over to Saurabh.
Thank you, Garnett.
Great.
Hi again, my name is Saurabh Chhabra. I'm a Senior Electronics Engineer in CIPD within WTB at the FCC. Today, my colleague Paul Dari and I will talk about small wireless facilities. I'll do the introductory presentation on 5G infrastructure, and Paul will be talking about Streamline Section 106 review of small wireless facilities. So let's move on to the slides. Thank you. So on agenda, we have an overview of cellular network, a brief overview, and then we'll talk about the different types of wireless infrastructure. As you're aware of macro cells, and you hear about small cells and DAS. We'll talk about what those are. We'll also cover why is there a need for these small wireless facilities, and how does that relate to 5G, and briefly talk about what 5G is as well. And then we'll look at some examples of deployments. And soon after that, Paul will jump in and talk about the Streamline Section 106 review of these small wireless facilities. Next slide, please. So here's a quick overview of a cellular network. Essentially, a few basic things to note here. One, a mobile phone is connecting to a tower, and this tower is generally a macro cell tower base station that you've seen while driving around. These are tall towers, and these towers then connect to the core network. And what you see here is essentially a mix of both LTE and 5G, which is the current state of events. The networks of today have the capabilities of both 5G and LTE networks. LTE has been the technology of choice for the last, I want to say the decade, and 5G is coming up and mingling with LTE, as well as will eventually replace LTE as a standalone 5G network. So essentially, you have a mobile phone connecting to the tower, then the tower connects to the core. But what you see with this tower is that it can be a macro tower, or it can be a small cell tower. Okay, so let's talk about what that might be, what that might look like. Next slide, please. So macro cells, as I'd mentioned previously, these are the tall towers, and they effectively cover large geographic areas, anywhere from 8 to 30 kilometers in radius, relatively high capacity, have antennas that are mounted on tall towers or rooftops of tall buildings, and they operate at high power levels as well. In comparison to small wireless facilities, facilities such as small cells and DAS, which are distributed antenna systems, can be deployed to provide coverage in targeted locations. So their radius could be anywhere from a few hundred feet to maybe a couple of kilometers in radius. But the idea there is to move these facilities closer to the user. And what that really does is provides additional capacity in those areas, in areas that have higher demand for voice and data services. It essentially improves the quality of service and experience for the user. These small wireless facilities use components that are a fraction of the size of traditional cell tower deployments and can often be installed on utility poles, buildings, and other existing structures. Next slide, please. So here's a quick look at what the macro tower looks like. This is a monopole with several antennas. Next slide, please. Here's an example of a lattice cellular tower, also a macro antenna structure. Next slide, please. Here's an example of one that's antennas mounted at the side of a building, and they're also camouflaged. This is, again, a macro cell antenna structure. And here, next slide, please. Here's an example of a stealth flagpole monopole. As you can see, these exist, but sometimes you won't notice that this is a cell tower because it's a stealth flagpole monopole. Next one, please. And you might have seen these. I heard somebody talk about them too. If you're driving around and you see vegetation of different colors, then this one looks the brightest and the most maintained. That could be because it's a stealth tree monopole. Next slide, please. So how does this compare to small cells? As we mentioned previously, small cells are closer to the user and they're smaller. They cover a small geographic area. So what's the definition of small cells? Now, small cell form defines a small cell as a low-cost radio access point with low RF power output, footprint, and range. And small cells can be deployed indoor or outdoors and in licensed, shared, or unlicensed bands. A small cell is essentially a cellular base station that transmits the same type of 3GPP RF signals with much smaller power and small form factors. So in most cases, it services a small coverage area. Now, there's been an introduction of virtualized disaggregated networks. Means that some small cells will consist of 2 or 3 elements, while others will still be all-in-one type small cells. Some form factors will be classed as mini macros, which can also be deployed unobtrusively on street furniture, but at performance and power levels close to those of larger base stations. Others will be so tiny they can be embedded in pavement or consumer electronics. So the types of small cells that you've typically seen have been femtocells, kind of like the ones you would have at your house to fill in any coverage needs. Then picocells could be indoor or outdoor small cells, and then microcells that generally provide larger area of coverage. So as I mentioned, these are essentially in increasing order of size or footprint. Next slide, please. And how does this compare to DAS? Well, DAS is a term used for distributed antenna systems. And as the name suggests, it essentially distributes RF signal from a central point to antennas located throughout a facility or area to provide seamless wireless coverage and capacity. So these are distributed nodes that you see in the picture that connect to a central hub. And these are typically used in large building, campus type settings, stadiums, other outdoor venues, city blocks, and applications of that nature. And these can also support a variety of frequency bands and technologies. What you see in the picture is DAS nodes connected via fiber and fiber connecting back to the central hub. Next slide, please. So is there a lot of difference between ODAS, which is outdoor DAS, or a small cell? When you look at these things installed on a light pole or a utility pole or a standalone pole, you may not know the difference between what might be a DAS install or a small cell install, because these things are generally small equipment are attached to the pole. Similar equipment is attached to the pole. They do need fiber boxes there. Well, not everything needs a fiber box, but there's generally a fiber box there. There's power there, and you might see an amplifier there, or you might see what looks like a small cell radio then connected to an antenna. So they look very similar and can generally serve similar purposes. Next slide, please. So what's the need for these small wireless facilities? Well, as you know, continuous increase in mobile traffic and required user data rates in today's 4G and 5G networks create the need for increased network capacity, which you can achieve one of three ways. One is to make more spectrum available. Two is to use that spectrum more efficiently. And three is to densify the network. And densifying really means is adding more cell sites to increase the amount of available capacity, or adding equipment to augment existing mobile network and provide additional capacity in areas of high usage. And DAS and small cells are identified as densification technologies and solutions. Next slide, please. So how does this fit in with 5G? Now, before we get into what 5G really is, what is 5G and what has it enabled or trying to enable as compared to the previous generations? So when we started with 1G in 1980s, the foundation was really just mobile telephony. And then we moved on to 2G, which further enhanced that mobile telephony. With 3G, we got a taste for mobile broadband. With 5G, we not just got a taste for the mobile broadband, but we devoured mobile broadband data over 5G networks. And what 5G is trying to do is embrace more of a network society. So essentially moving beyond just providing high-speed data, as you'll see in the next few slides. Next slide, please. So these are usage scenarios defined by ITU about what 5G should try to accomplish. And one of the pillars is enhanced mobile broadband, and in short, EMBB. You'll see these terms used. And the other pillar is ultra reliable and low latency communications, or URLLC, or massive machine type communications, which is also termed as IoT. Now, all of these different usage scenarios need different things, and there are overlaps between what they need too. So for instance, enhanced mobile broadband simply means higher speed data, right? And ultra reliable and low latency communications really means I want that higher speed as well as lower latency so that I can have higher reliability of exchange in data. And massive machine type communications don't rely too much on really high speeds. They can in the future, but essentially they rely on lower speeds, but connections that are very reliable. So 5G usage scenarios are expected to cover all three of these pillars. Next slide, please. So here's a look at ITUR 5G requirements. As you can see, downlink peak data rates are expected. The requirement is to be at 20 gigabits per second for the EMBB scenario. Now, this is a peak data rate. but the user experience downlink data rate is expected to be around 100 megabits per second. For the uplink case, user expected about 15 megabits per second. Latency is expected to be around 4 milliseconds for the mobile broadband usage, or as close as to 1 millisecond for the ultra reliable low latency communications. Bandwidth, there's a lot more bandwidth available with 5G. The connection density is going up to almost 1 million devices per unit area or square kilometers. And the peak downlink spectrum efficiency is going up as well. So these are for different use cases, and we'll see the benefits of all these being implemented into 5G networks. Next slide, please. So how does that compare to 4G? Well, 4G download speeds with the latest version of 4G, meaning the LTE advanced version, you can see peak data rates of 1 gigabits per second, and 5G is expected to be at 20 gigabits per second. Bandwidth is increased. You can use a lot more bandwidth. You have access to a lot more bandwidth because you have more spectrum available in 5G networks. For 5G networks, you have the usual bands that 4G can access, and 5G is also making use of millimeter wave bands, which has a lot of bandwidth available. Download speeds for 4G networks are anywhere from 10 to about 50 megabits per second on LTE, and with 5G they're expected to be at about 100 megabits per second or more. Now this is real world expected user data rates. As I mentioned previously in latency, 4G is anywhere from 10 to close to about 40 milliseconds in latency, and 5G is expected to be at anywhere from 1 to 4 milliseconds. Next slide, please. And here's a slide talking about S&P Global Market Intelligence that projects, a report by them that projects more than 800 small cells being deployed by 2026, as compared to macro towers of today. And the macro towers of today are anywhere in the hundreds of thousands, so close to about 154,000. The point here is that these projections may not be consistent with future deployment plans of mobile service providers, but the gist is that there are macro towers today, a good number of macro towers, but small cells are expected to eclipse that amount and maybe even go close to about 5 to 10 times that amount in the near future. Next slide, please. So there are a few examples of deployments of small cells in DAS now. Next slide. Here's a form factor that is essentially an equipment cabinet that puts different pieces of a small cell or a DAS together. You'll see remote radio head compartments, power supply compartment, disconnect switch, battery compartment, all put into a neat and tidy enclosure. Next slide, please. Here's one that could be found on a rooftop platform, small cell deployment. These are generally out in a place that's hidden from view anyway, but essentially it's an equipment cabinet having those disconnect switch and other power equipment to connect it and offer service in that local area. Now this equipment is most likely connected to antennas that are installed at the side of the building or stealth in some structure of the building. Next slide, please. Here's a small wireless facility in the historic Central Park. As you can see, this is a light pole, and you see some equipment on that light pole really high up, and then there's an antenna all the way at the top. Next slide, please. Here's one on a lamppost in Pittsburgh, Pennsylvania, historic area. And what you see is essentially a light pole, and it's converted or upgraded to conceal the equipment that the small cell has, and then it has a canister antenna all the way at the top. Next slide, please. Here are a few more examples of small cells on utility poles that you might have seen while driving around. Essentially, these have, again, equipment on the poles, antennas on top, and sometimes you won't even notice that there are antennas on top because the equipment on the pole might integrate an antenna in itself, and it might still be actually placed higher up. So there are all kinds of different configurations for putting these small cells on poles, utility poles, light poles, sides of buildings even. Next slide, please. Here's an example of one on a lamppost. You see two antennas in two different directions and equipment so close up to those antennas. Next slide, please. And here's yet another example of a small cell pole that's a stealth pole. Essentially, equipment is hidden inside the pole structure, and it's stealth in a way that it doesn't give out that this is an antenna. The antenna is all the way at the top, a canister antenna, and there might actually be a smaller panel antenna right underneath it, or could just be a supporting structure. But the point is that these things can be integrated into our communities, and they look different based on where you're looking. Go ahead. Next slide, please. That concludes my part of the presentation. I'd like to ask Paul to join in and talk about the Streamline Section 106 review of small wireless facilities. Paul?
Thank you, Sarah. So I'm going to cover how the environmental and historic preservation review processes for small wireless facilities have been streamlined to reflect the fact that these facilities are smaller and less visible than macro cells and less likely to have effects on historic properties or on the environment. And to understand the context, it is important to keep in mind that many small wireless facilities are co-locations, and the actions taken to streamline small wireless facilities, the review of small wireless facilities, was an extension of the Commission's earlier actions to streamline review of co-locations. Next slide, please. So for Nhpa review, small cells that are co-locations generally qualify for the Commission's categorical exclusion adopted in 1986 for the deployment of facilities that are co-locations. And in general, co-locations are categorically excluded from detailed Nhpa review, and the provider is not required to submit an environmental assessment. There are two exceptions, though. This categorical exclusion is not applicable to deployments that would cause human exposure to radio frequency emissions in excess of established guidelines, and it is not applicable to deployments that may affect historic properties that are listed in or eligible for listing in the National Register of Historic Places. Next slide, please. Okay, so the categorical exclusion for co-locations does not address historic preservation review under Section 106. But in 2001, the nationwide programmatic agreement for co-locations was adopted, And this co-location NPA excluded most co-locations on towers, buildings, and other non-tower structures from Section 106 review. There are two notable exceptions, though. This original co-location NPA did not exclude co-locations on or near any historic buildings or structures, and it did not exclude co-locations on buildings or structures that were over 45 years old. But with the development of small wireless facilities several years later, it created an opportunity to expand the exclusions to include these categories under certain circumstances. Next slide, please. And so in 2016, the Commission, the Advisory Council, and the National Conference of State Historic Preservation Officers amended the co-location NPA to provide additional Section 106 exclusions for small cells. And the amendment expands exclusions in two categories. Under certain conditions, it excludes small cell co-locations on buildings and structures regardless of age, including those that are more than 45 years old, as long as the buildings or structures are not historic properties or in or near historic districts. And it adopted more limited exclusions for small cell co-locations on buildings and structures that are historic properties that were in or near historic districts. Next slide, please. So with regard to buildings or structures that are more than 45 years old, small cell co-locations are excluded from Section 106 review unless the building or structure is located inside a historic district or is visible within 250 feet of a historic district, or the building or structure is a designated National Historic Landmark or listed in or eligible for listing in the National Register. Or the small cell co-location causes new ground disturbance. Next slide, please. Also, small cells on buildings or structures more than 45 years old must meet specified size limitations. Each individual antenna may be no more than 3 cubic feet in volume, and if there is more than one antenna, 12 cubic feet cumulatively. And the equipment associated with the antenna may not exceed 21 cubic feet on poles and 28 cubic feet on non-pole structures. The provision also encourages neutral hosts by increasing the permitted size of associated equipment if the co-location arrangement can accommodate at least 3 providers. And in such cases, the volume limit for associated equipment is 28 cubic feet for poles and 35 cubic feet for buildings and other non-tower structures. Next slide, please. So the amendment also created exclusions for the deployment of small cells on or near historic properties in 3 categories. And the first category is a general exclusion for small cells on or inside historic properties or inside or near historic districts. Second category is an exclusion for small cells installed on utility poles or electric transmission towers that are historic properties or inside or near a historic district. And the third category is a streamlined process for small cells on lighting structures in historic districts. Next slide, please. So first I'll go over the general exclusion. The general exclusion for deployments of small cells co-locations on buildings or non-tower structures that are historic properties or in or near historic districts has the following conditions. The building may not be a National Historic Landmark. There May be no pre-existing antennas on the building or structure. The antenna must be disguised or stealthed to complement the building or structure. The antenna on the building or structure may be no larger than 3 cubic feet. The antenna's associated equipment may not be visible from public streets or public spaces at the ground level anywhere within 250 feet of the historic district. And the deployment may not cause new ground disturbance, except that there may be up to 4 lightning grounding rods. Okay, next slide, please. The second category is the exclusion for small cells on utility structures in historic districts. The co-location of a small cell on a utility pole or an electric transmission tower located inside or near a historic district is excluded, provided that the structure is not a National Historic Landmark. The antenna does not exceed 3 cubic feet in volume, with a cumulative limit of 6 cubic feet if there is more than one antenna on the structure. The antenna's associated equipment on the structure does not cumulatively exceed 21 cubic feet, and there is no new ground disturbance except that there may be, again, up to 4 lightning grounding rods. Next slide, please. So the third category is a streamlined process for small cell co-locations on structures that have the primary purpose of providing public lighting. And small cell co-locations on lighting structures that are located in or near historic districts may be eligible for an exclusion, or at least a streamlined process, as long as a structure is not a designated National Historic Landmark or listed in or eligible for being listed in the National Register, and the antenna is no more than 3 cubic feet in volume, with a cumulative limit of 6 cubic feet if there is more than one antenna, and the associated equipment on the structure may not are cumulatively no more than 21 cubic feet in volume. Okay, next slide, please. And assuming a small cell deployment on a lighting structure meets the conditions that I just mentioned, it may seek an exclusion by taking the following steps. First, the applicant must determine that the lighting structure on which the small cell will be deployed is not a contributing or compatible element within the historic district. Next, the applicant must request in writing that the SHPO concur with its determination that the lighting structure is not a contributing or compatible element within the historic district. The SHPO then has 30 days to respond, and if the SHPO either informs the applicant that the structure is not a contributing or compatible element, or fails to respond to the applicant within 30 days, the applicant has no further Section 106 obligations. Next slide, please. So this is the final exclusion I want to talk about. It's not in the co-location NPA. It is an exclusion for replacing utility utility poles that was adopted by the Commission in a report and order in 2017. In this report and order, the Commission excluded from Section 106 review, under certain conditions, the replacement of a utility pole where the pole was not originally constructed for the sole or primary purpose of supporting an antenna for FCC licensed service. This exclusion was adopted in part to help expedite the deployment of small wireless facilities on utility poles. The exclusion also complements the exclusion adopted in the 2004 NPA, which excludes from Section 106 review under certain conditions the replacement of a tower that was originally constructed for the sole or primary purpose of supporting an antenna for FCC licensed service. But again, the utility pole exclusion is for the replacement of poles that were not constructed for the sole or primary purpose of supporting an antenna for FCC licensed service. Next slide, please. All right, so to be more specific, a utility pole replacement will be excluded from Section 106 review if both the original pole and the replacement pole meet certain conditions. And to be excluded, the original pole must meet these conditions. It must have been a pole that can hold a utility communications or related transmission lines. And again, the pole must have been originally erected for the sole or primary purpose. I'm sorry, it must not have been originally erected for the sole or primary purpose of supporting antennas that operate pursuant to spectrum license or authorization by the Commission. And the pole itself may not be historic property. Next slide, please. And okay, so that was for the original pole. The pole replacement also must meet certain conditions as follows. So the location of the pole can be no more than 10 feet away from the original pole. And this distance is calculated from the center point of the replacement pole to the center point of the original pole. Also, the replacement pole may not create new ground disturbance either laterally or in depth. The height of the replacement pole may not exceed the height of the original pole by more than 5 feet or 10% of the height of the original pole, whichever is greater. And the replacement pole must be consistent. The appearance of the pole must be consistent with the appearance and quality of the original pole. Next slide, please. So I have one last very important point to make about this exclusion. The replacement pole exclusion applies to the replacement of the pole alone. The exclusion does not apply to the antenna. In the 2017 report and order, footnote 25 provides that antennas are considered separately deployed and are subject to the Commission's rules implementing Section 106, including the terms of the co-location Npa. So applicants seeking to locate small wireless facility antennas on utility replacement poles that are excluded under the 2017 replacement report and order must remember that the exclusion does not apply to the antenna, and they must consult the co-location agreement to determine if the antenna and associated equipment may qualify for a Section 106 exclusion or require a full review. And with that, I think Saurabh and I are ready to take questions.
Thanks, Saurabh and Paul. Very helpful. We do have a few questions. The first one, I think I will go ahead and take. Someone had emailed and asked if there's an FCC contact or website that can help applicants to better understand our Nhpa and Nhpa processes. What we recommend is that applicants take a look at our website. The link is on the first set of slides that George had done earlier today. It has the complete link, and we've recently updated our website, including the Nhpa checklist, which I think will be extremely helpful for applicants. And so I encourage everyone to walk through our website in detail, both the Nhpa and Nhpa processes, as well as ASR. And then I'm going to hand it to George. He's got a question.
I have another general question, and I will be taking this one. So the question is, are weather unlicensed whether wireless micro towers that are using unlicensed spectrum are subject to environmental review. Towers using unlicensed spectrum are not subject to our Nhpa review. That being said, if you expect or anticipate that these towers might have future collocations using licensed services, we would suggest that you undertake our Nhpa review. And of course, just because an unlicensed tower is not subject to our Nhpa review does not mean it is not subject to other agencies' Nhpa reviews or other rules. And of course, feel free to email us and email FCC staff with specific questions about proposed projects if you do have any questions on what would fall within our rules.
Okay. Paul, we have a question we think you might be able to take. Okay. According to stipulation 7 for replacement of small wireless antennas in the Second Amendment of the Co-location Npa, a small antenna on a building can be replaced without being reviewed through Section 106 process, provided required criteria is met. Can this stipulation be applied to rooftop macro sites if the antennas that are replaced are either the same or smaller in size than the original antennas that are being replaced? Now, Paul, that is
that is a long question, and there's a lot of facts in there. So
okay. No, I take that. I mean, maybe what we can do, we've put the question out there, and we can certainly respond to it by email. Given, sometimes with these very fact-specific questions, it does take a little time to think and make sure we've got, all the considerations in mind when we give an answer. And so what we'll do is we'll respond by email to that. Is there anything else? I think that might be it. And so that leaves us time for lunch. We're just on schedule. I'm impressed. We're right at 12:30. So everyone, we've got 45 minutes. And then we come back at 1:15. Just as a reminder, everyone should, in person, keep your badge. There's maps at the back of the room for places to eat, delis and so forth. So take a look at that. Again, no food here, but when you return, it should be quicker if you keep your badge and everything. Okay? Thanks again. See you at 1:15. Welcome back. I hope everyone got some food and roaming our new neighborhood here. This is a new building for us, so we're still getting accustomed to all the lunch locations. So we're now going to start the afternoon sessions. Our next panel will focus on tribal outreach requirements under the Nationwide Programmatic Agreement, which will be presented in person by Sairi Rajapaksa, Acting Chief of the Office of Native Affairs and Policy within the Consumer Government Affairs Bureau, and Jill Springer, the FCC's Preservation Officer, Federal Preservation Officer, and Associate Division Chief of the Competition and Infrastructure Policy Division within the Wireless Bureau. And so now I'm going to hand it over to Sairi, and she's going to begin. Thank you, Sairi.
Thank you, Garnet. Good afternoon, everyone. As you just heard, I'm Sairi Rajapaksa, Acting Chief of the FCC's Office of Native Affairs and Policy, otherwise known as ONAP. I'm going to briefly discuss the unique status of Indian tribes, the role of ONAP within the Commission, and specifically, the role of ONAP in tribal consultation and the Section 106 process. Section 106 covers the 574 currently recognized, federally recognized tribes, and also Native Hawaiian entities. The important thing to emphasize here is that the tribes are unique. They are not stakeholders in the sense that other special interest groups are. They are recognized by the federal government as sovereign nations. In 2000, the Commission adopted a tribal policy statement that recognized tribal sovereignty, federal trust principles, and the importance of agency consultation with federally recognized Indian tribes. Among other things, the policy statement reaffirmed the commitment to promote a government-to-government relationship between the FCC and federally recognized Indian tribes, and recognized rights of tribal governments to set their own communications priorities and goals. 10 years later, in 2010, the Commission created ONAP and charged it with bringing the benefits of modern communications infrastructure to all Native communities. It works within the Commission, as well as with other government agencies, to develop and implement policies for assisting Native communities. ONAP serves as the FCC's official liaison for ongoing consultation, coordination, and outreach to the American Indian, Alaska Native Village, and other Native communities. ONAP is tasked with ensuring robust government-to-government consultation with federally recognized tribal governments, and that Native concerns and voices are considered in all relevant Commission proceedings and initiatives. ONAP also represents the Commission's positions on matters of interest to tribal entities. We're usually the first point of contact for tribes within the Commission. However, the office works closely with the Wireless Telecommunications Bureau on all Section 106 matters, and often on these matters, the Wireless Bureau is the primary point of contact for tribes. We tend to get involved at the behest of the Bureau if things become problematic to try to help reach a resolution. At times, tribes may want to discuss sensitive historic or cultural preservation matters confidentially with ONAP in its role as the Commission's tribal liaison. I should note that when a proceeding does become restricted, ONAP can confer confidentially with the tribes as long as it follows guidelines established by our Office of General Counsel. It's important to emphasize that tribes have to voluntarily agree to work directly with applicants, even in specific instances where, in accordance with the rules, an applicant may be standing in the shoes, so to speak, of the Commission. The Commission maintains the ultimate responsibility for making certain that consultation occurs. I should also note that tribal nations seek consultation with the Commission on a broad range of matters, from Section 106 to spectrum access to broadband deployment, generally by requesting it through ONAP. At this point, I'll stop and turn this over to Jill Springer, the Commission's Federal Preservation Officer, to get into the details of tribal outreach requirements under the Nationwide Programmatic Agreement. Jill?
Thank you, Sairi. So I wanted to start out by talking generally about the National Historic Preservation Act and tribal historic preservation. So I'm not going to read these slides specifically. We've talked this morning about Section 106, what it does and how a historic property is defined. But it's important to know that properties of tribal significance were not eligible for the National Register until 1992. So tribal consultation is really key, and it's necessary to identify tribal historic properties. So those changes to the National Historic Preservation Act in 1992, the amendments also established tribal historic preservation officers, or THPOs. And THPOs may assume the responsibility of state historic preservation officers for projects on tribal lands, and they may participate in Section 106 reviews of projects off tribal lands as consulting parties. So next slide, please. The ACHP's rules talk about the distinctions for projects on tribal lands and projects off tribal lands. So consultation on tribal lands, the agency would consult with the designated THPO in lieu of the SHPO regarding undertakings occurring on or affecting historic properties on tribal lands. And that happens where you have a THPO that has been designated by the National Park Service to serve that function. For tribes that have not assumed SHPO functions, the agency consults with a representative that's designated by the tribe, in addition to and on the same basis as consulting with the SHPO. And that might be for the undertakings that are actually occurring on tribal lands or affecting historic properties that are on tribal lands. When a project is off tribal lands, the agency consults with the tribe basically as a consulting party. So I think most of the folks who are tuning in or are in the room today are familiar with the tower construction notification system that we're going to be discussing, and the fact that we have projects that require notification of a number of tribes who have areas of interest that are beyond their physical tribal land boundaries. So under the nationwide programmatic agreement, there are some streamlining measures and some special rules that apply with respect to tribal outreach. The NPAs require the identification of Indian tribes and Native Hawaiian organizations that may attach religious and cultural significance to potentially affected historic properties. And those properties may be not only on tribal lands, as mentioned before, also on ancestral lands, Aboriginal lands, and ceded lands. The NPA allows the use of Tower Construction Notification System, TCNS, as representing a reasonable and good faith effort to identify tribes that might be interested in a project area. So an important point that I think you'll hear several times in the next couple of slides is that the NPA requires applicants to follow tribes' preferred communication preference. And sometimes that's email, sometimes that is reviewing a project through our E106 system, but there are still a number of tribes who request to get information via the U.S. Postal Service. And the reality is that there's not great broadband in all tribal lands. And as everyone who deals with Section 106 knows, cultural resource reports involve a lot of photographs and a lot of maps, and they can be very data intensive. So it's very important to know that the NPA does require an applicant to follow a tribe's preferred communication preference. Applicants must always be sensitive and respectful in communications with tribes, to provide all of the information that's reasonably necessary for a tribe to evaluate whether historic properties may be affected. And then the NPA also requires a reasonable opportunity for the tribe to respond, and that's usually 30 days from information receipt. So the goal, next slide, please. The goal, from my perspective, and I think from everybody who is handling the Section 106 review of these projects, tower projects, is for an applicant and a tribe to reach an agreement on the presence or absence of effects that may obviate the need for a full consultation or for government-to-government consultation. But when a tribe identifies a historic property, an applicant needs to invite the tribe to become a consulting party and should also notify the FCC. Where a project may affect a historic property, the applicant will consult to avoid, minimize, or mitigate the effect. And sometimes that will be directly with the tribe where it agrees, and sometimes either the tribe or the applicant may request that the FCC become involved. Next slide, please. So the Tower Construction Notification System, TCNS, I think that Christine mentioned it this morning. There will be another session on kind of the technical aspects of TCNS, but it is a voluntary system that's proprietary to the FCC. It was developed to facilitate the identification and contact with potentially affected tribes. It's very important to know that tribes and Native Hawaiian organizations designate their own geographic areas of interest in the system, and the FCC generally protects this information as confidential. I mean, you will see when you initiate a project a list of the tribes that have been notified, so you do get that information, but we don't give lists of tribal areas of interest to any other entities. An applicant will initially put some basic project information into TCNS, like the project coordinates and basic project description, who the project proponent is, and that information will process through to the tribes as an initial notification. And at that point in time, That initial notification may, in some cases, provide a tribe with enough information for them to determine whether or not they have interest in continuing to participate in that review. Again, TCNS provides notification. It doesn't substitute for the Section 106 process or government-to-government consultation unless at that point in time that the project information is initially provided, the tribe disclaims interest in participating any further. So next slide, please. So following that TCNS notification, it will process out and the applicant will receive a TCNS number. That number is used to initiate a filing in our E106 system after the full review of the project site is done. And once that review has been completed and the Form 620 or Form 621, all of the components, which might include, it could include an archaeological survey, includes photographs, as Christine discussed earlier today, mapping, and other information. Once all of that information is available, that is filed in the E106 system, and the E106 system will start the tribal review clock. So there are certain categories of facilities that don't require Form 620 or Form 621. Specifically, NPA sections 3D and E discuss facilities that are proposed in industrial parks, strip malls, or shopping centers, and facilities that will be in utility or communication rights-of-way. These are excluded from SHPO review under those NPA sections, but these deployments still require tribal participation. So the Commission's second wireless infrastructure report and order, which was adopted in March of 2018. Okay, just for a second there, I thought I was off a slide. Established an alternate submission packet and requirements for what information has to be provided to a tribe when the Form 620 or 621 is not completed. So these submissions must include the contact information of the project proponent, project coordinates and mapping, the facility and site descriptions, and aerial and site photographs. This information, like the Form 620 and 621, needs to be provided to a tribe via its preferred communication method. Next slide, please. So the report and order that I mentioned previously clarified a number of Section 106 tribal participation requirements. It addressed tribal review fees, information requests, tribal review timeframes, and contracting issues. Disagreements with tribes about these requirements should always be referred to the FCC, and the best first way to do that initial notification is by emailing tcnshelp@fcc.gov. It's important to keep in mind, however, that despite all of these clarifications, it's very important that the R&O clarifications maintain that responsibility to identify tribal historic properties as part of the Section 106 process. Non-responsive tribes may be referred through the TCNS system once they've had 30 days to review the Form 620, 621, or alternate submission packet. And tribes that respond initially to the TCNS notification and then go silent or otherwise have a reason why they can't be referred through the system may be referred on the website, www.fcc.gov, TCNS-manual referral, by following instructions that we provide online. Next slide, please. So the tribal review clock begins to run on the date that the tribal nation has received the required information. Again, that could be the form or that could be the alternate submission packet. That's got to be provided to the tribe via their preferred means. And the way to determine how a tribe prefers to receive information is very frequently listed or described in the Notice of Organizations. After you do an initial TCNS filing and it processes out to the tribes, applicants will receive kind of a report, which is called the Notice of Organizations, and that will list all of the tribes that have been notified of the project, and it also has an opportunity for those tribes to provide information back to the applicants clarifying how they prefer to be contacted. So in order for the clock to start, applicants must provide a complete and accurate submission package. The clock will generally start once that Form 620 and 621 is completely uploaded into the E106 system. The alternate submission packets, however, have a different process. The information that is required for those projects must be uploaded at the time of the initial TCNS filing, and the 30-day review clock would start at that point. So applicants should follow up with the tribe to confirm receipt of all information. And in that follow-up, that courtesy follow-up, please definitely communicate that the contact is being made just as a confirmation and a courtesy, and it's not any kind of an indication of tardiness. Next slide, please. If a tribe does not respond within 30 calendar days of receiving the required information, and that is if it receives the information electronically, our system allows an extra 5 days for tribes that prefer to receive information by U.S. Postal Service. The applicant can refer the matter to the FCC for follow-up. So it's important to know that once that 30 days or 35 days for mailed submissions is over, the obligation to the tribe is not necessarily over. Once the referral is done, the FCC is going to attempt a follow-up where we first send an email or a letter to the tribe and then follow up with a call to the tribal TCNS contact. So the best way, from our point of view, the preferred way to refer a tribe, if it's possible, is to do it through the TCNS system. Before you do that, however, there is a detail that we ask that you check. Certain tribes have indicated that no response equals no interest. We call it NRENI, and that language would be in the additional details. So where that language appears, no referral is necessary. The tribal notification requirements would actually be considered complete. Please check for it before referring. Once we send out our letter or email to the tribe, after 15 days, we've made our attempt to contact them. The applicant may move forward with construction at that point, provided that they've met all of the other Nhpa and other review requirements, unless we notify you of some outstanding issue directly. Next slide, please. So as I mentioned, the 2018 report and order addressed tribal review fees, and largely the R&O relied on ACHP guidance. Consistent with ACHP guidance, applicants are not legally obligated to pay upfront fees when providing tribes with the opportunity to comment on proposed facility deployments for Section 106 purposes. Tribes are free to request upfront fees, and applicants may, if they choose, voluntarily pay such fees. We always recommend that parties mutually agree on the terms of any compensation in advance. There is a distinction, however, if a tribe or where a tribe might condition its response on the receipt of upfront compensation. The R&O clarified that again, neither the ACHP nor the FCC require applicants to pay Section 106 fees. And when that happens as a first response, an applicant should respectfully, refer to that clarification and reiterate the invitation for them to comment, for the tribe to comment on the project. At that point, if the tribe does not comment by the end of the review period, the applicant is able to refer the tribe to the FCC as non-responsive. So consultant services, another area that the RNO covered. An applicant may ask a tribe who is participating in a Section 106 review to conduct surveys or to perform other services for which a negotiated fee is appropriate. If the applicant and the tribe can't agree on a fee, the RNO established that the applicant may seek other means to fulfill its reasonable and good faith identification obligation on behalf of the Commission. The applicant is not presumed to be required to engage the services of any particular party to assist with identification, monitoring, or mitigation, but it is very important that an applicant use a properly qualified consultant or contractor where expert services are required. And I think Christine hit this several times with respect to general Section 106 identification and evaluation. That professional should meet the relevant Secretary of the Interior's professional qualification standards. So again, with respect to tribal historic properties, traditional knowledge may be required to assess the significance of above-ground features or to identify archaeological properties of significance to tribes or to monitor construction. If an applicant is going to hire a tribe as a consultant, like any consultant, an agreement regarding compensable services should be executed before any services are performed. If an applicant and a tribe disagree on whether the applicant has met the good faith standard of identification, either party may ask the Commission to decide whether the applicant's obligations have been satisfied. And in the case of a dispute, the applicant has the burden of substantiating its claims within 15 days. Following that, the objecting party, in this case a tribe, would have 15 days to make their case. It is important to note that under the NPA, as with the NHPA, tribal, religious, and cultural sites are treated differently. They are basically, it's very important that the tribe is a very key point in identifying those properties. They are, because the eligibility of tribal historic properties came so much later than regular archaeological or architectural properties, they're less likely to be found in the SHPO and other archival areas and in the National Register of Historic Places. So in addition to the contact that's required, the engagement of a tribe, there are cases where it may be necessary to, for a tribal member or a TIPO staff to do additional research in order to determine the significance of a site. If that happens, if this issue, again, begins to get more complicated, FCC's staff can always assist in clarifying requirements upon the request of either the tribe or the applicant. There is a dispute resolution process that is established in the RNO when there are disagreements between applicants and tribes over what constitutes reasonable and good faith identification efforts. Next slide. Again, tribal historic properties are frequently not identified in SHPO records or listed in the National Register. Some of the other distinctions here, the NPA allows tribes, as it allows SHPOs, to request an expanded APE. Anytime a tribe identifies a historic property that is potentially affected, that tribe should be invited to become a consulting party. We do expect that the identification of a historic property of tribal significance will involve a recognized tribal authority, and that tribal authority is going to provide a boundary or an area for the site that will allow avoidance of the site or will clarify what's going to need to be done for minimization or mitigation. And importantly, not only in our NPAs, but in the NHPA and the ACHP's rules, we don't need to know details of why a site has religious or cultural significance to a tribe. So it's important to know, Sari talked about tribes as sovereign nations. Tribes are definitely not uniform in their views of federal undertakings. Very frequently, TIPOs and their staffs, and certainly elders, tend to be more traditional in their view of the importance of tribal religious and cultural properties. In some regions, very large geographic areas have traditional meaning and continue to be actively used by tribes. And for some sites, the knowledge about the importance of a place may be restricted to certain clans or families. Once again, we don't require that tribes explain their religious and cultural beliefs, only that a recognized elder or tribal representative has identified the area as important. So again, only tribes can identify their historic properties. These might include tribal cultural landscapes and traditional cultural properties. These type of resources might not easily be recognized by academically trained archaeologists. There is evidence of tribal sites and also, distinct views that different tribes have of different areas or different sites. I have a quote here that's from a BOEM study, the part of the Department of Interior, that gives an example of that an archaeological site can have culturally significant plants and modified trees that are evident above ground, peeled bark, coppiced, which is pruned to encourage new growth, a lithic component like a stone tool underground, and possess a viewshed of an important cultural or spiritual location, such as a mountain. The complexity inherent in these types of places is understood by the communities that inhabit and interact with them. And it's important always to protect the location of all tribal sites if that information is shared with you. So as I mentioned earlier in the presentation, any general questions on tribal participation requirements, any specific issues that you're having with a project, or any concerns as a matter of practice, send an email to tcnshelp@fcc.gov. Myra Delau is our staff member who very capably manages that box generally, and she will direct your inquiry to the right person. We have a whole support team in addition to myself and Christine and Myra, Connie Diaz, Leanne Jackler, Don Johnson, Matt Hartnett are some of the other folks that you may be dealing with. And I think with that, we can take some questions if we have some.
Jill, we received some questions on tribal fees.
Okay.
So I'll just read, there's a few of them. We won't have time to read all of them. I apologize to those who sent the questions. Here you go. Several tribes request fees which they define as not upfront. However, in these cases, the fees to initiate the review, which in the questioner's opinion would qualify as an upfront fee. In the past, the questioner has notified TCNS Help of these differences of opinion, and they wanted to confirm the FCC's process for handling these scenarios, and what are the options beyond notifying TCNS Help. And finally, if the FCC needs to be notified each time this scenario presents itself, or just a representative scenario.
So probably the first option that comes to mind is to pay the tribal fee voluntarily, if that is something that is amenable to you, if you're just asking for options. But generally, as indicated in the presentation, I think that if it's been a little while since you have reviewed the sections of the report in order, which we encourage, very frequently when we get direct questions about tribal fees, we point applicants back to what was specifically said, because that report in order went into great detail about how these, basically what at what point something is a consultant service versus something is an upfront fee. So that that guidance in the earlier part of the presentation of very gently pointing out the clarifications that were made in the report and order and how the request that's being made doesn't square with the guidance that the commission provided is the first step. And then the second step is basically to reiterate the invitation to comment on the project. And then, as the slide mentioned, if at that point in time the tribe still elects not to comment on the project, that project would be referable at the end of the review period if no response was received. It is a better. I would just say, because this is an area of sensitivity, particularly if there is a new kind of response, we do encourage you to contact us through TC&S Help, and we are happy to reach out. Very frequently, tribal governments will have had elections and replaced some of the TIPO staff, and the newer staff coming online may not have been working back in the 2018 time period to fully know the clarifications that the commission made at that time. And we are happy to walk a new TIPO through what the report and order says and explain to them where what they're requesting doesn't square with what our applicants are required to do. So that would be my recommendation.
Thank you, Sari and Jill. We do have other questions. We're just tight on time. So thank you again. I thought Jill did a good job it was a broad answer to the question, which I think might hit upon some of the other questions we received. So thank you, both of you. So for our next panel, we're going to discuss working with TC&S, the system review, reminders, and manual referral process. Diane Dupar, Chief of the Technology, Systems, and Innovation Division of the Wireless Bureau, will present for us today virtually. So hopefully Diane will pop up here soon enough. There we are, Diane. Excellent to see you. And just to note, Diane, you're on, I think you might be on mute over there in the corner. Are you on mute? There we go.
I am.
Excellent, Diane. Thank you. I'm going to hand it over to you.
Good afternoon. I'm going to present a TC&S system overview that includes some reminders and a review of the manual referral process. TC&S is designed with unique secure logins and permissions for each type of user. When an applicant logs in with their FRN password, the system only allows them to see and work on their projects that they submitted. They cannot see or search for any other applicant's projects. Neither can they see or search for tribe contact information or their geographic areas of interest. Tribes are assigned a unique FRN password. Their login only allows them to view and reply to projects that are within their areas of geographic interest. They can manage and update their contact information, methods for receiving system notifications, and their geographic areas of interest. So let's first take a look at the applicant's login and workflow. So we're going to take a look at submitting a new filing, referring a notification, and the notification details display. And some of the features we're going to focus on are those that we implemented with the effective date of the infrastructure second report and order back in 2018. Next. After logging in, the applicant will see this list of notifications, and these would be the notifications that they submitted in the past. And to submit a new notification, they would click on that link in the upper left-hand corner, submit a new notification. Next. Applicants have an option to indicate a project is excluded from SHPO review. When when applicable, they check that little box and then complete the rest of the screen, which includes the tower owner information, consultant information, mailing address, phone number, and email address. It's important with respect to the email address because the TCNS system uses that email address to send all automated notifications, which includes the notice of organization email that lists the tribes notified about the project they submitted, and all of the replies that the tribe submits through TCNS are sent to this email. So it's important to ensure this email is a valid email and the email account you want to use going forward. Next. The next screen allows the applicant to indicate the type of structure and the coordinates, an address and a geographical description of the location of the structure and heights. For a project that is excluded from Nhpa review, an alternate submission packet is required to be uploaded. This alternate submission packet must include a map of the proposed location of the facility, a description of the facility to be constructed, and all proposed elements, such as access roads. And it should also include a description of the proposed site, including both aerial and site photographs. To upload this type of document and any other relevant documents, the applicant will click on the Add Attachments button or link. Next. That link takes them to our attachment utility, which allows the applicant to select a pre-filled attachment type and allows you to view and search your computer for the document, upload it, and you can enter your own description for that document. Once all of your documents are uploaded, you click the return button and you're returned back to the proposed structure data page. Next. Once back on this page and all attachments have been uploaded, you can click the continue button. Next. For a structure that is excluded from Nhpa, we'll see this icon at the top of the display, this red circle with a yellow E. This page is a summary page and allows the applicant to review all of the information about the project they've submitted so far. It allows them to edit any information that is wrong or incorrect. Once all information has been validated and all attachments have been uploaded, they click the Submit Notification button. Next. And if an alternate submission packet attachment type hasn't been uploaded and is required, they'll get this error message, and you'll be able to exit that error message, go back, and upload that required attachment. Next. Once the notification has been submitted, a TCNS number is displayed here on the confirmation page. Projects that are exempt from Nhpa review and projects that require Nhpa review are all processed on the same weekly schedule. Every Wednesday, the system takes all notifications submitted the week prior and processes out the weekly notice of tower construction notification emails and letters to the tribes. And then on Fridays, processes out the notice of organizations emails back to the applicants. The notice of organizations email includes a listing of all of the tribes notified about that project that week. Next. Projects that are exempt from Nhpa review and projects that require Nhpa review, again, are processed on the same weekly basis. And the 30 and 35-day tribal review period begins for projects excluded from Nhpa review with the date of the weekly notice that is sent to the tribes. The 35-day tribal review period for projects that require Nhpa review, that period starts and is related to the Form 620 and 621 submission date, and the date that the E106 system processes out the email or letter notification to the tribe. Next. Here's an example of the weekly notice, email, or letter that is sent to the tribe. It includes their contact information, and it lists their geographic areas of interest that are currently in the system, and then it lists all of the projects submitted that week for their review. Next. Here's an example of the Notice of Organizations email that is sent to back to the applicant, and it will list all of the tribes notified that about that project, including tribal contact information, the method in which the tribe received their weekly notice, either mail or email. And it will also include any exclusions or additional information the tribe wants them to know about their review process. Next. So now we'll take a look at referring a notification. Projects that are excluded from SHPA review will display the icon, the red circle. And when a when a project is ready for referral, the link "Refer this notification" automatically displays by the system. For projects excluded from SHPA review, this link will appear on day 31 after the weekly notice is sent to the tribe. For projects that require SHPA review, this link will appear on day 31 after the E106 system notifies the tribes that the FCC Form 620 or 621 has been submitted. Next. So tribes who have not submitted a reply will become available for referral on day 31 after the related E106 notification is sent by email, or on day 36 if the related E106 notification was sent by letter. That is for projects that require SHPA review. Projects that are excluded from SHPA review, the notification, the tribe does not become available for referral until day 31 after the weekly notice is sent, and on day 36 after the weekly notice is sent by letter. Once the applicant selects the tribe for referral, they click the Continue button. Next. And the confirmation page is displayed, and it notifies the applicant their referral successfully submitted, and the system will also send an email confirming the referral. Next. We also have a method to refer a project where initial contact to a tribe was not made through TCNS. At the bottom of the list of notifications page, there is a link, Refer a Notification. Next. This workflow includes 2 data entry screens and a summary page where the applicant has to submit the initial tower or structure owner and structure project information. Next. And then they are presented with the referral screen where the system has determined, based on the project information submitted on the prior screens, has determined what tribes would have received notification about that project. The applicant then can select the tribes and then is required to enter the date that they contacted the tribe outside of TCNS. Next. Confirmation page then will display confirming the referral was submitted successfully. And TCNS continues to process referrals on a weekly basis every Thursday. And that process generates two notifications. One, the final request for indication of interest to the tribes. And the other notification is the final contacts email that goes to the applicant, letting them know, confirming the projects that were put through the referral process that week. Next. This is an example of the notification of final contacts email that goes to the applicant, and it lists all of the notifications processed that week and the tribes that were included in that referral. Next. This is an example of a final request for indication of interest that would be sent to the tribe. Next. Okay, we'll take a look at viewing the notification details on the update status screen. The list of notifications, as I stated earlier, the notification ID number is a link to the notification details. So we'll take a look at that. Next. The applicant has an opportunity to update the status of a notification they've submitted from proposed to either abandoned or constructed. And again, the new information regarding the Form 620, 621 available on date and the related E106 file number is included on this display. Next. Next. And one more, please. Okay, we'll take a look now at the tribe FIPO or NHO login view, and we're going to focus on the E106 system notifications, replying to a notification and search options, and the FCC approval process for additional details. And we'll take a look at the changes made there again in 2018 with the effective date of the infrastructure report and second report and order. Next. These are the E106 system notifications, and again, they have an email and a letter. And in these notifications, we've added the Form 621 question and answer. Has the communications tower or non-tower structure been the subject of SHPO-FIPO review? And we've also added the tribal review period end date. And this is the last date that a tribe can reply before they are considered eligible for referral. And this date is determined based on the tribe's TCNS notification preferences, whether it's email or letter. Next. During the reply option, the tribe will see, again, any project that is excluded from SHPO review, and they will be identified by the red icon, the red circle icon. And to view the notification details and any attachments that were submitted with the notification, they click on the notification ID. Next. And they will see this notification details page. They will also see the tribal review period end date, which tells them the last date that they are eligible, that they can reply before they are eligible for referral. And they will again see the icon indicating a structure excluded from SHPO review. If they want to see any attachments like the packet, the submission packet, they will go to the bottom of the page and click on the View Attachments link. Next. The View Attachments link will take them to a screen that will list all of the attachments uploaded with this project. And then they can click each document that opens in a separate window, allowing them to review the additional information that was uploaded with the project. Next. This is a display for a project that requires SHPO review. And this displays the other additional information like the Form 620, 621 available on date. And this is the date that the tribe was notified of the related 620, 621 filing. And they will also see their tribal review period end date. And they will have a link to the related E106 file number. Next. The tribe also has an option to search for a specific TCNS notification. And the details displays, again, will display all the relevant information and the new information specific to whether or not the project is excluded or requires SHPO review. Next. The search results page will display the icon again if the project is excluded from SHPO review. And we'll display the E106 file number, the 6/20/21 available date, and their review period end date, and a link to the E106 filing. Next. Okay, we'll look at the FCC approval process for additional details that the tribe might want to enter. Next. The tribes are required to enter their text for FCC approval before they are used in the system notifications to the applicants. So they click in this text box and they enter their details, any information they want to go back to the applicant regarding their review process. The status will remain pending FCC pending FCC approval, and until the FCC reviews and actually goes into the system and approves that additional detailed information. The tribe will click continue and get to a confirmation and summary page. Next. The tribe will be able to review their text, make changes, and confirm the additional detailed text that they want to enter. Once they hit the submit button, next, the staff, FCC staff review and approve additional details on a daily basis. And FCC staff may reach out to a tribe to discuss the content of the additional details text before approving that new language. Next. The tribe will receive an email notification when the FCC has reviewed and approved the new or modified additional details. Once approved by the FCC, the additional details text will be included in the notice of organization's email that is sent to the applicant. Next. Okay, now we'll move over to an overview of the TC&S manual referral process. If an applicant does not receive timely responses to their TC&S submission from a tribal nation or Native Hawaiian organization, the applicant may refer the matter to the FCC for follow-up. In most cases, the applicant can rely on an automated referral via the TC&S system itself. However, in some cases, automated referral is unavailable, and a manual referral must be submitted. Since the effective date of the infrastructure second report and order, we have updated the manual referral process by implementing an online web form to submit data previously submitted in a specified format via email. Next. Prior to referring, applicants must ensure a few things. First, that the E106 filing review period has commenced and the information was delivered by their preferred means of the tribe. That the 35-day period is up. Referrals become available on the 31st and 36th day. Third, that the tribe did not provide a valid response to the project in TC&S. Fourth, that the tribe has not indicated no response equals no interest. We should note as well that you should not refer a tribe that has provided a specific and substantial response. A request for fees, however, is not considered a response in this context. And we have further guidance about that in our Q&A document that is posted on our website, and I'll give you that link later in the presentation. And we should also keep in mind that when a tribe provides a specific and substantial response in TC&S, automatic referral through the system is not possible, and you'll have to use our manual referral process. Next. TC&S manual referrals must be submitted through our FCC website on a form that is available at this URL here displayed. The manual referral process relies on human processing by both applicants and the commission staff, so accuracy and organization is critical here. Next. These next few slides is what the online web form looks like. And you'll note that all required data fields have a red star. And so we collect the referrer name, email address, the TC&S number, and whether or not the project required SHP overview. Next. We also collect the E106 file number where applicable, and the project location. And there are drop-down boxes to select tribes that are being referred for this project. And we have additional email addresses for other contacts in the referral process. Next. We collect from the applicant the method of delivery and the date the documents were sent. The applicant can send us additional comments with specific information about this referral. And we also have an attachment utility as part of this web form where the applicants can upload documents and other information that supports the referral of the tribes and this project. Next. Referrals that have been submitted by 11:59 each Tuesday will be included in that Thursday's notifications to the tribes. There we have a manual process where we take the information submitted on these web forms and we update the TCNS system to include these referrals in that automated referral process that occurs every Thursday. We have manual referral processes, information, and question and answers documentation posted on our antenna and tower siting webpage. There's the URL for that webpage, and you have to scroll down a little ways on that webpage to get to this section 106 tools and be able to access our documents with all of that information. Next. Any information, as Jill stated earlier, any questions you have about TCNS or a specific project or referral, you can always email tcnshelp@fcc.gov. Any questions or issues that you have about the system can be reported through our customer support hotline at that number there using option 2. You can also submit an online help request at that URL. We have an online support services form to ask questions or report system issues. So now we'll take any questions.
Okay, Diane. The first question is, can licensees with multiple FRNs compile the account access to see all FRNs under one general licensee? Unfortunately
not. They could create one FRN to use in TCNS and submit a request to help to then combine all of the notifications submitted under the multiple FRNs under one account. But there is no like a super user login that we can link different FRNs to, unfortunately.
So a second part of this question is, are the TCNS APIs, which we think means application programming interfaces, open access for use so that we may compile the data from multiple FRNs?
Unfortunately, we don't have an API for TCNS at this time. That's something I can certainly take back as a future enhancement.
And we have another question. Which time zone is used for the 11 a.m. referral?
Eastern time zone.
Okay. We'll take one more question. Actually, two of them, we'll meld them together. And Diane, I'm going to go ahead and take this. What are the responsibilities of the applicant when there are issues with contact information provided by the tribes in the NOO? And the second question was, what is the FCC doing to try to keep TCNS contacts current? So the second question first, there are 574 federally recognized tribes, and these tribes are constantly having elections, and we understand that staff is turning over. And unfortunately, we do our best to keep up with changes in staff and to provide direct assistance to TIPO offices and cultural resource offices in updating their information, but we are more on the receiving end. So it's very important, the second part of my answer here, when you have issues with the contact information that you receive in the NOO, immediately notify TC&S help at fcc.gov. We are going to attempt contact with the TIPO office. We talk to tribes frequently, and we're going to reach out to try to see what's going on. If we are unsuccessful in that type of access with the TIPO office, we are very likely going to request that our colleagues in ONAP, SIRI, and the others in the ONAP office reach out directly to tribal leadership to basically explain the problem that we're having and to get any updated information that they have. If for some reason tribal leadership isn't able to assist, we would assess what is necessary and reasonable to meet that standard that we've talked about a couple times today in Section 106, which is the reasonable and good faith effort for identification. And I think with that, we might be running a couple minutes late, but thanks, Diane, that was great.
Thank you, Diane, it was great. And I have to call out Diane is just, it's a privilege that she's part of our team and just knows her stuff inside and out and is always a creative thinker whenever we have issues with TC&S. So thank you again, Diane. Okay, we're on to our next panel. It's very exciting. It'll focus on Nhpa, migratory birds, and endangered species. As our speakers, I'd like to introduce Debbie Spring, biologist for the Competition and Infrastructure Policy Division within Wireless, and our guest speaker, Joelle Gehrig, biologist from the U.S. Fish and Wildlife Services, both in person. I'm imagining many of you know Joelle as an alum of the FCC, so we're thrilled she's able to be here in person all the way from Michigan. So thank you again, Joelle, for coming. We are definitely, I'm so thrilled to see her in person. Thank you. Debbie, I'll hand it over to you.
Thank you, Garnet. Good afternoon. My name is Debbie Spring. As some of you already know, I am taking over the FCC biologist position. Just to give you a little background, I'm a marine biologist with extensive ESA knowledge. My previous experience including working at the National Marine Fisheries Service, also known as NOAA Fisheries, for 9 years. I conducted formal consultations which included writing biological opinions on various large-scale projects that could potentially affect ESA-listed species. I also have a number of years of additional federal experience as a natural resource specialist, reviewing projects to verify that impacts are reduced and to ensure compliance with Nhpa and other environmental laws. Today, I'll be talking about our new FCC Nhpa checklist, threatened and endangered species as it pertains to ESA, and finally, migratory birds and tower lighting. Once I am done, I will then hand it over to Joelle. Next slide. As some of you know, we have recently updated the FCC Nhpa and EA checklist. You can find it on the FCC's Tower and Antenna Siting webpage, which is the first link on the left-hand side. On the right, you can see a screenshot of where on the page the link to the new Nhpa checklist is located. Under the FCC Mpa Process section, I've also included a link directly to the checklist. Next slide. On the right, it shows what the new checklist looks like. On the left are the 10 FCC Nhpa EA triggers. Any one of these triggers will need for submittal of an EA. Those triggers are if it's located in an officially designated wilderness area, located in an officially designated wildlife preserve, may affect listed species or jeopardize the continued existence of listed species or likely result in the destruction or adverse modification of critical habitats, may affect historic properties, may affect Indian religious sites, will be located in a floodplain and will not be placed at least 1 foot above the base flood elevation, Construction will involve significant change in surface features, will be equipped with high-intensity white lights, which are located in residential neighborhoods, would cause human exposure to levels of radio frequency radiation in excess of commission-adopted guidelines, or if the facility will be over 450 feet above ground level. Just a reminder, if you're submitting an EA due to any of the above triggers, please remember to include the total footprint of the project, which includes the fenced area around the facilities, as well as any roads or utility easements. Also, if the tower will have guy wires and will involve tree removal for the guy wire paths, that area needs to be included in the total footprint of the project as well. Also wanted to mention that this checklist is a summary of the rules. We recommend referring to our rules to make sure you have covered everything. Next page. Next will be an overview of the Endangered Species Act and the possible effects construction of proposed facilities might have on listed species and or designated critical habitat. Next slide. The Endangered Species Act, ESA, provides a framework to protect and conserve endangered and threatened plants and animal species and their habitats. The ESA requires the FCC, in consultation with U.S. Fish and Wildlife, to ensure that any action it authorizes is not likely to jeopardize the continued existence of any threatened or endangered species. The Fish and Wildlife maintains a list of threatened or endangered species. Applicants are required to determine if species and or critical habitats are present at their proposed facility sites and assess what kind of effects will be caused by the proposed action. A qualified biologist must make this determination. The FCC public notice PNs provide guidance on procedures for ensuring the applicants protect the northern long-eared bat and the American burrowing beetle. Links to the PN are provided. To comply with Nhpa, applicants should also consider potential impacts on state protected species and habitat. And since I'm pretty much the only one that has really pretty pictures, other than Joelle, the image on the left-hand side is of the Schweinitz sunflower, which is one of the rare sunflower species in the US, the top one, and is endangered, and the northern long-eared bat, which is the next one, which is currently listed as threatened, but will most likely be uplisted. Next slide, please. Section 1.1307A3 requires applicants to consider the impacts of proposed facilities under the ESA. Applicants must initially ascertain whether proposed facilities may affect listed species or designated critical habitat. Once again, a qualified biologist must make this determination. Applicants are required to notify the FCC and file an environmental assessment if any of these conditions exist. Next slide, please. These are the three effects determination under the ESA. There is the no effect, the may affect not likely to adversely affect, and the may affect likely to adversely affect. The next few slides will go into more detail for each of these. The no effect, either no species or designated critical habitats are present, or species are present but would not be affected by the proposed project. For projects that do not require an EA, the applicant should document in its record how it ascertained there would be no effect and retain these materials. For projects that require an EA for a different Nhpa trigger, the applicant must provide the information described in the previous bullet in the ESA section of the EA to explain how it reached the no effect determination. Next slide. If a proposed facility may affect but is not likely to adversely affect listed or proposed species or designated or proposed critical habitats in the action area, the applicant has to obtain a letter from Fish and Wildlife Service concurring with the applicant's determination. If measures are proposed to mitigate effects on the species or habitat, the EA must outline those measures and include evidence of the Fish and Wildlife concurrence and list any mitigation credits required. Next slide. An informal biological assessment identifies projects that may affect, not likely to adversely affect listed or proposed species or designated or proposed critical habitats. The IPAC system provides an informal biological assessment when the applicant enters the necessary information. We will walk through the IPAC process very briefly later in this presentation. The applicant can initiate informal consultation with Fish and Wildlife Service directly. Next slide. The last of the determinations is the may affect, likely to adversely affect. In this case, a biological opinion is required for projects that may affect, likely to adversely affect listed or proposed species or designated or proposed critical habitats in the action area. A biological opinion is a document that states the opinion of the Fish and Wildlife Service, or NOAA Fisheries, as to whether the federal action is likely to jeopardize the continued existence of listed species or result in the destruction or adverse modification of critical habitat. Biological opinions provide measures to mitigate the take of listed species. They also specify the extent of take allowed, as well as the reasonable prudent measures to minimize impacts from the federal action, and the terms and conditions with which the federal agency must comply. Next slide. If species and/or habitat are present and the proposed facility may affect and is likely to adversely affect, the applicant is required to, first, prepare a formal biological assessment and provide it to the FCC. The FCC will then initiate formal consultation with the U.S. Fish and Wildlife. The Fish and Wildlife will provide a biological opinion to the FCC, which may include best management practices, known as BMPs, an incidental take statement, and/or other mitigation requirements. An incidental take statement is issued to a federal agency as part of a biological opinion and estimates the amount or extent of incidental take of listed species likely to result from the action subject to consultation and exempts that take from ESA Section 9 take prohibitions. The applicant then prepares and files an EA describing the formal consultation with Fish and Wildlife, its results, and requirements. Next slide. This slide summarizes what was explained in the previous slides regarding the ESA effects, determination, and the requirements each has and what the applicant must provide. So I'll just quickly go through them. So if there's a protected species not present, applicant is required to retain the relevant documentation in their files. If the protected species are present but will not be affected, requires determination by a qualified biologist or Fish and Wildlife Service. Not likely to adversely affect protected species, requires an informal biological assessment and Fish and Wildlife Services concurrence letters. This documentation must be included in an EA if prepared. The EA must describe any conditions or mitigation commitments. Likely to adversely affect protected species, requires a formal biological assessment submitted to the FCC. FCC initiates formal consultation with U.S. Fish and Wildlife. U.S. Fish and Wildlife prepares a biological opinion. The EA must include measures outlined in the biological opinion. And Fish and Wildlife Service may include an incidental take statement in the biological opinion. Just to further explain, mitigation banking is a system of credits and debits devised to offset losses to endangered species and/or their habitat or wetlands and streams resulting from various developmental works, which is compensated by the preservation and restoration of natural habitats, wetlands or streams in other areas so that there is no net loss to the environment. Conservation banks are regulated and approved by Fish and Wildlife Service and/or the National Marine Service, and wetland or stream mitigation banks are regulated and approved by the Army Corps of Engineers or the Environmental Protection Agency. Next slide, please. This is a screenshot of the tower and antenna siting page previously provided by many of the other speakers, as well as my slide 3. Under the ESA section, you will find the FCC's guidance on both the northern long-eared bat and the American burying beetle. Just to give a further information regarding these two species, the 40 rules is used to streamline ESA compliance for actions that result in low levels of take but do not threaten a species' continued existence. The 40 rule only applies to threatened species. The Fish and Wildlife Service developed programmatic consultations and an online determination keys to further streamline the consultation process on these two species, since there are numerous and various projects within their habitat that could potentially affect them. Next slide, please. The next few slides will be a quick overview of the Fish and Wildlife Service Information for Planning and Conservation, otherwise known as IPAC tool, that can be found in the following link. You can also find the link to it in the ESA section on the tower and antenna siting webpage. Next slide. If you follow the link provided, it will bring you to the IPAC webpage. Once you have logged in, which allows you to save your project, you can enter your project location either by coordinates, by street name, or even upload a shapefile. Once you have found the general location of the proposed project, you can select a drawing tool, which allows you to further define the area. It even allows you to change it to satellite view, which in my opinion makes it a lot easier to find your proposed site. Once you are satisfied you have included the complete footprint of the project, including all the guy wire paths, if required, and easements as part of the project, you can then hit continue. Next slide. Once the project location has been identified, this page will show what listed candidate species could potentially be present, as well as any migratory birds. Next slide. If you want additional information on the species that are present, you can click on the image and a brief pop-up, which kind of looks like this, will show species-specific information. For additional information, there's a link at the bottom, by the green, that will lead you to the official listed species profile page, which is part of the Fish and Wildlife's Environmental Conservation Online System, ECOS. Next slide. In this area to the left, highlighted by the green circle, also shows a snapshot of what resources might be affected, other resources might be affected by the project. Next slide. Once you have set the project location, you can start the regulatory review either by clicking on the tab found in the circle above or by the blue button on the right-hand side. Next slide. If you use the tab feature, it will lead you to this page. As you can see, you can click here to start the ESA review. Next slide. Once you have clicked on the Start ESA Review, it will proceed to this page. Hit the Continue button at the bottom to finalize your consultation package. It will walk you through the process, including any determination keys that might apply to the proposed project, including asking if you want to submit the project for Fish and Wildlife Service verification. The verification letter will contain information about the project and the determination key results, if there is a determination key. Should an EA be required, this letter should be attached as one of the documents in the appendices. Next slide. The next couple of slides will be on migratory birds and FAA tower lighting options. Next slide. As of 2012, it was estimated that around 7 million bird fatalities resulted from migrating bird collisions with communication towers in the United States annually. Most frequently detected bird mortalities were the songbirds, the vireos, warblers, thrushes, and sparrows, as well as the shorebirds and waterfowl. Studies have shown that guide towers result in higher levels of avian mortality than towers without, as well as taller towers result in higher levels of avian mortality than shorter towers. Joelle will speak to it further in her presentation. The birds on these slides is, the top is the American yellow warbler, the bottom left is a red-eye vireo, and the bottom right is an ovenbird. Next slide. The FAA released a revised advisory circular November 2020. It's the AC 70/7460-1M, and there is a hyperlink in the PDF once you guys have the slides. Next slide. Prior to December 2015, legacy lighting options were a combination of steady and flashing lights. Studies have shown that steady burning lights on towers result in higher levels of avian mortality than flashing lights. By eliminating non-flashing lights, there has been a 50 to 70% reduction in fatalities. Next slide. After 2015, the updated lighting options are that steady lights are not required in most instances. Next slide. The FAA lighting standards are to extinguish non-flashing lights on towers over 350 feet above ground level and to reprogram non-flashing lights to flash on towers between 150 and 350. These standards are applied to new construction and encouraged for existing towers. In most cases, there is no need to climb towers. There is little to no additional cost to change lights. There are financial savings due to lower energy usage, lower maintenance costs, lower construction costs, and of course, most significantly, the reduction in bird fatalities. Currently, LEDs are the best option for reprogramming the non-flashing to flashing. Next slide. The next two slides give a detailed explanation of the lighting deviation process. To extinguish or eliminate tower lights or side markers on existing registered towers, first, you have to file a marking and lighting study electronically with the FAA, requesting the elimination or omission of steady burning lights, or requesting that steady burning lights flash with Form 7460-1. It's called a Notice of Proposed Construction or Alteration. Designate structure type deviation from red obstruction light standards. Next slide, please. Once FAA has approved the request and assigned an FAA study, file FCC Form 854 via the ASR. Select MD modification and choose appropriate FAA lighting style. The FCC typically approves applications within 24 hours. Once lighting changes have been granted by the FCC, L-810 steady burning lights can be extinguished on towers taller than 350 and reprogrammed to flash in concert with L-864 lights on towers between 150 to 350 feet. As mentioned before, this typically does not require tower climbing. Per the FAA requirements, flashing red lights should flash at 30 flashes per minute, plus or minus 3. Next slide. For all proposed antenna structures, the FCC recommends downshielded motion detector lighting on buildings, if lighting is required for security purposes. For all antenna structures above 450 feet, an EA must be prepared specifically addressing the potential impacts to migratory birds. In this picture, this little guy is a Cape May warbler. Next slide. Here's my contact information, and now I will hand it over to Joelle.
Thank you. Thank you, Debbie. I'm so happy to be here, and I was really happy to get the invitation to come back, not just to see all these awesome familiar faces, but to be reminded of how complicated a lot of this stuff you guys do is. There's a lot of good minds that go into making these regulations usable and applicable to everyone, and usable. And so it's impressive, all the work that goes into it, and I'm very happy that you guys are here today learning about it. So yes, happy to be here. I'm used to work with the I used to work with the FCC, and now I'm with the U.S. Fish and Wildlife Service. I'm with the Division of Bird Conservation, Permits, and Regulation. And I still get to work on towers, which is good because it's been my very favorite topic that I've worked on for the last 19 years. I've been working on communications tower issues with migratory birds. And I also work on reducing bird collisions with glass now. And I also lead the Council for the Conservation of Migratory Birds, which I get to work with Debbie on as well. So it's a fun group of things I get to work on, but it's always great to come back to the FCC. So thank you, Deb, for introducing the topic and helping us understand the changing in lights that can reduce up to 70% of migratory bird fatalities. I'm going to talk a little bit more about that and talk about this win-win option for the tower industry and migratory birds. And then I'm also going to go into what goes into a Fish and Wildlife Service review of a project when it comes from a migratory bird perspective. So as I mentioned, I work with the migratory bird program. I don't work I work directly with, but I don't do environmental review from the Ecological Services, or the ESA perspective, but I work with those people, and I've worked with it enough here at the FCC that I'm familiar with it. But today I'll be talking mainly about migratory birds. So next slide, please. Okay, so I can see it in the back. There we go, great. So yes, so as Debbie mentioned, we have a significant increase in the numbers of towers that are lit with only flashing lights at night. And these are the communications towers that are involved in significantly fewer bird collisions. So not only are these tower operators saving money while reducing the need for maintenance and climbs, but they're also reducing bird fatalities. As Debbie mentioned, the process is typically fast and easy. And I understand, we were just listening to some of the forms that have to be completed with communications towers project approval. It's not all forms online are easy. This is an easier process than a lot of these. So I encourage people to not be overwhelmed by the prospect of tackling this. Those who have embarked on the process of reducing bird collisions with towers and reducing their tower lighting have found it to be fast and easy for the most part. And it is definitely a win-win. It results in immediate cost savings from $500 to $1,300 a year, depending on the height of the tower and how many lights you're extinguishing. And as we know, energy costs are increasing right now. And if there are ways that we can reduce those energy costs, you know I go for it in my personal life. And this is another opportunity to not only reduce bird collisions, but to save money. And you know the steps to go through this of going through the FAA and then going through the FCC and updating their database, those can be considered the difficult steps. I've heard many tower owners say to me that the easiest step was going to the tower, going to the control room and flipping that switch, and then telling the alarm, no, it's okay that those lights are off. But it's a pretty easy process, especially once you get through the hoops. And I noticed some people, you know, taking some notes on those steps. The FCC used to have online, and I think you still do, January 2017 document detailing those steps. And I actually printed some off from my file. So I hope it's still on your website. Okay, good. And that is available at the back of the room. So you can pick that up on your way out if you'd like, to have those steps in hand of what you need to do to extinguish those tower lights. So next slide, please. So we have seen an exponential increase in the numbers of towers that are lit with bird-friendly lights. People are grabbing onto this. They are understanding the benefits of it. And as I mentioned, it's one way to battle rising costs. And I encourage those of you who have not extinguished lights on towers yet, or that work with people who have not, to consider it. You're saving money and you're reducing bird collisions at the same time. And to join this party of people who are making the most of it. So next slide. And as I mentioned, you know, there are other reasons for reducing these tower lights. Birds, while energy costs are increasing, bird populations are decreasing. And I know we hear a lot of challenging things in the world that we need to face. This is one of them, but we have opportunities to reverse that change. I want to take a minute to point out that bird in the middle image there. By the way, we've lost almost 3 billion birds since 1970. That's in my lifetime. And that's a big number. So our populations have decreased by almost 3 billion birds, according to Rosenberg et al. In the Science publication from 2019. And that image in the middle of is a Baltimore oriole. A lot of us know that species. You know, that comes. We see it in our towns. We see it in our at our oriole feeders. We have teams that use the Baltimore oriole as their motto. Mascot, thank you. And this species in particular, 2 in 5 of them have been lost since 1970. That's a lot. You know, this is a species that is important to many of us because we have that interface with this. In time, we have big trees here in the east. They nest in these cool little pendulum nests that hang down. They eat oranges. I know I bought groceries for my mom online during the pandemic, and she bought a lot of oranges and grape jelly, and I knew she was not eating those oranges. And they were for her Orioles, and she spent a lot of money on them, and she loved them. And she would tell me, oh, the adults brought the babies, and they're teaching them to eat oranges, and she loved it, you know? And so this is a species that we can relate to that is disappearing before our eyes. Another species, and these are just species that are highlighted in the Loss of 3 Billion Birds paper, is the eastern meadowlark on the far right. That's a species that we've probably all heard, just maybe didn't know what it was, in grassland areas. 3 out of 4. You know, that's a huge reduction since 1970 in that species population. And it's overwhelming and it's kind of scary. What do we do? And the Fish and Wildlife Service is taking steps, as Cornell and individuals are taking steps. And if you're interested in learning more about this, there's 7 simple steps online that you can look at to see what we can each do. But the people in this room and in this industry have an opportunity to help reverse this. And if you go to the next slide, please. We have reasons to be optimistic. The same publication showed increases in birds, such as raptors or birds of prey, increased by 15 million since 1970. They're going up. That's a good thing. Waterfowl, 35 million. That's a huge increase in waterfowl since 1970. And why? Because we figured out what we needed to do, and we did it, right? We needed to get DDT out of our system. We needed to stop using it. We needed to get it out of our milk that our kids were drinking. We needed to get it out of our system. The raptors responded by increasing. With waterfowl, we realized the importance of clean water and the Clean Water Act and wetlands for our own well-being, for our, we want our kids to be able to have fresh water to drink and to play in, and our dogs to be able to jump in. And all of that is related to the increase in waterfowl. So when we figure out what we need to do, we can all play a part in it and benefit from it. And this is no different. Those people who have indeed extinguished their side marker lights are playing a role in reversing that decline of migratory birds, such as the Baltimore Oriole. They are taking steps. I can sit here and talk about it. The industry is the one who's really making the difference. They are the ones flipping the switch on the lights and filling out the forms. So I would like to encourage people to realize how many opportunities we have to not just reduce our energy costs and save money, but also help reverse this decline of migratory birds. Next slide, please. So as Deb mentioned, we lose about 6.8 million birds a year in the US and Canada, and that's from Long Corridor 2012. Maybe that number isn't so big anymore because we are seeing more tower lights lit in a more bird-friendly way. It would be nice to get another study out there to see how we're doing with that. And the Fish and Wildlife Service is talking about it. We'll see if we get the money to do it. We know how that goes. But we are seeing this exponential increase in the numbers of towers that are lit with bird-friendly lights. So I wanted to take this moment to not just talk about this statistic of losing 6.8 million birds per year in the US and Canada, but to also talk about the fact that these are the migratory birds. These are not the house sparrows and the rock pigeons that we're going to see when we step outside this building. But these are the migratory birds, the warblers, the vireos, the tanagers, the orioles that we're losing. And why? Because they are amazing at migrating long distances. They can migrate over the Gulf of Mexico with no water and no food. That's a big feat right there. And they can do that after hatching from an egg, 2 months earlier. It's impressive. It's amazing. They can do that, but they aren't always able to recognize that a bright light on a tower or a cruise ship or a football stadium is something that they should avoid. And they tend to be drawn into those lights as like a moth to a porch light, especially when weather is cloudy and they're unable to see the stellar constellations. So again, these are birds, tiny little birds the size of my thumb, that are migrating across the Gulf of Mexico and farther. They're migrating from Alaska, the Arctic, down to South America. And some of these birds, there was a red knot that we had banded. It's a shorebird, and the Fish and Wildlife Service had banded it, and it was documented to have made, I can't remember if it was 6 migrations. It had gone to the distance it had migrated was farther than to the moon and back in its lifetime. And that's a bird about this big. Incredible. How do they do that? They use stellar constellations. They use polarization of light along the horizon. They use landmarks such as the Mississippi River or the coast of the United States. They also use stellar constellations, polarization of the light, magnetic fields of the Earth, and sometimes landmarks as well. Kind of depends on where they are in their migration, how high they are, etc. But this is a tough task for them to accomplish, and the more we can make it easy for them, the better, especially if we save money doing it. I just want to point out that most of these birds that are colliding with towers are also protected by the Migratory Bird Treaty Act. And so that's another thing we have. Some of them are also protected by the Endangered Species Act. Okay, next slide, please. So we talked a little bit about birds and collisions and what's going on, but what seems to happen is when their stellar constellations are obscured from view, such as inclement weather, clouds, rain, or snow, that's when the birds tend to be more attracted to steady burning lights. So are all towers on the landscape involved in bird collisions? They have the potential to be, but those that are located in areas that are foggy or experience inclement weather are more likely to be involved in bird collisions. Those towers that are located near bird concentration areas, bird migration areas, wetlands, etc., are more likely to be involved in collisions. And as Debbie mentioned, tower support system, tower height, and tower lighting systems. Those are all things that are within our control that are related to bird fatalities. Next slide, please. Whoops, my circle didn't quite make it oval, but you get the point. Next slide. So different computers are a little different here. So as we mentioned, taller towers and towers with guy wires are involved in more bird fatalities than shorter towers and self-supported towers. And this graph is from data collected from a Michigan study we did that the FCC and Don Johnson, going way back, were a part of organizing and getting going. And I had the honor, and it was a true honor, to be part of that initial work in 2003, starting in 2003. Next slide, please. Okay, so same type of graph, same types of graphs here, but I wanted to point out that this graph is more about lighting. Okay, so when we have towers on the landscape, we're not going to take the guy wires off, and we're not going to make them shorter usually. But we can change the lighting. And if the tower is already lit with white flashing lights at night, this is what we're talking about at night, is the most critical part, you know, that's good for birds, or really reduces bird fatalities. But if we have that old traditional red flashing lighting system that includes levels of L810s or non-flashing lights and levels of L864s or flashing lights, those are the towers that are really attracting in migratory birds. And I did want to point out that even though the birds might not collide with an unguided tower, they might still be attracted to that. And if you're thinking about long-distance bird migration, you're thinking about running that marathon, but you decide that halfway through that marathon you're going to stop and play around a basketball and circle around a tower, you're going to get worn out pretty fast. So I recommend that, and the Fish and Wildlife Service recommends that all towers reduce their non-flashing lights and only light with flashing lights at night, because even if the birds are not colliding with the tower, they are wearing themselves out circling around these towers when they really have an ultra marathon to be running. Okay, next slide. Okay, that one came out a little different too, but I'll read it for you. The background's supposed to be black, but 50 to 70% reduction in fatalities via eliminating non-flashing lights at night. Okay, so these are the L810s that we think about, or the side markers. A lot of people call them side markers. And by extinguishing these side marker lights or reprogramming them to flash, we can reduce those bird collisions by 50 to 70%. And when you think about 50 to 70% of 6.8 million birds a year, that's a lot of birds. And so it's a real opportunity for people to save money and reduce bird collisions. Okay, next slide, please. As Debbie mentioned, we had a new advisory circular come out in December of 2015 that made this, we had the conspicuity study before that, so people could extinguish side marker lights before 2015, but this made it more official. And so starting in 2015, people were allowed to extinguish the side marker lights on existing towers or reprogram them to flash. But it became required of new towers going forward. So this was updated, as Debbie mentioned, in 2020 with M. This is 70/7460-L, 1L, and this next one is M. So they both recommend the same lighting systems for towers. Next slide, or next click. And I wanted to point out that Transport Canada, some of you maybe work with the industry in Canada as well, and Transport Canada has very similar lighting recommendations, so that's like the FAA version, Canadian version, and they very similar. It's not required for new towers going forward, last I heard, but it is recommended as well, and it's definitely an option. Okay, next slide. All right, so to summarize again, towers taller than 350 feet above ground level, no tower climbing is typically required to make this change. There's no additional cost or fees to extinguish these lights. You don't have to, pay the FCC or the FAA to review this. Nope, it is a online form there's no fee attached to it. There's a financial savings due to decreased energy costs, decreased maintenance costs, decreased construction costs, and of course, not as much tower climbing, right? And we know the safety aspects of that as well, and a 70% reduction in bird fatalities. But for those towers that are 150 to 350 feet AGL, currently LEDs are the best option for reprogramming those non-flashing lights to flash. The incandescent lights are just, I'm not a tower engineer, but my understanding is that it's not really possible to reprogram those incandescent lights, those LED10s, to flash. But the LED lights do work. Again, 70% reduction in bird collisions with just a slightly different tweak to the approach there. I think the FAA just really wanted multiple levels of lights on those towers. So with the taller towers, they can just extinguish side markers. With the little bit shorter towers, they need to reprogram those side markers to flash. Next slide, please. So again, same slide as before, but I wanted to congratulate those who are indeed using towers with no flashing lights, no side markers, and to encourage those who have not done it yet to do that, to do so. And every migration season matters, right? Just like every power bill matters. Every energy bill matters. And so I encourage people to do this as soon as they can, and to maybe catch some of this fall migration season and definitely next spring migration as well. And again, there's guidance on the table in the back. And if anyone ever runs into any problems with going through that process with the FAA, the FCC's process is very fast and it's automated, is my understanding. It's 24 hours and the system is updated to reflect the new lighting systems. The FAA can be just, you know, moving paper and virtual paper through. And it can take a little bit longer. And if it gets to be longer than 3 weeks, I always suggest people just give me an email, or I'm not going to volunteer Debbie, but just reach out to me because I'm very happy to reach out to that particular FAA field office in a very polite manner and just say, hey, is there anything else you need from us? Because this is going to help migratory birds. Most of them are very used to this by now and are very willing to make the switch pretty easy. But if you run into problems, just feel free to reach out. I'm very happy to help in any way that I can. It's tower by tower, right? And bird by bird. And we can do this, and it's exciting. Now, there is a video that I was hoping to show at the last part of the presentation, and it sounds like there was an issue with the audio, and so I'm not sure if the AV people can hear me right now, but if anyone's able to just Google win-win tower birds, you can find that video, and you'll be able to watch it. It's like 4 minutes long, and the video includes some really great friends and mentors and prominent people in this industry. Jimmy Miller from NATE, National Association of Tower Erectors, is featured in the video, as well as Richard Hickey from Vertical Bridge. And he used to work with flash technology as well. And they both, they tell me, you know, this is great stuff. We're saving money and we're saving birds. And I say, I'm not saving the birds. You guys have saved far more birds than I have. I'm not the one flipping the switch on the base of the tower. So I encourage you to take a look at that video. It's 4 minutes long. It's a pretty cool video, and it helps people understand the steps and why it's important. Okay, so the next part of my presentation, I would like to talk a little bit about what the Fish and Wildlife Service does when they're looking at reviews, at least from the migratory bird perspective. So next slide, please. So most of us are familiar, and Debbie highlighted the need to contact the U.S. Fish and Wildlife Service field offices in many cases. Sometimes the IPAC will show that there's not really a reason to, but migratory birds are not all captured in IPAC. Birds of Conservation Concern, or BCCs, are included in IPAC, but not all of them are. And so it's worthwhile to reach out to the Fish and Wildlife Service to learn a little bit more about what they might suggest. So again, first step we have for our recommendations are to work with the U.S. Fish and Wildlife Service field office. And then the next slide, please. Same slide, just highlighting some different bullets. It is important to try to co-locate equipment on existing tower structures or use existing tower farms. Now, this is from the Fish and Wildlife Service perspective. I do understand the industry says, you know, we're not just building towers randomly. We're putting them where they need to be, and we're making them as tall as they need to be and as, you know, supported as they need to be. And I do understand the other constraints on tower development. But it is helpful, and your review process will be streamlined if you can co-locate on equipment or existing tower structures or use existing tower farms. Okay, the next slide, please. So these next 3 bullets are about selecting where the tower goes, if you can do that. I understand the limitations. The towers are going where they need to go, right? But if we can select already in ecologically degraded areas, a cornfield is going to be easier to develop from a conservation perspective than is, you know, a forested area in a remote area. So selecting those degraded areas will speed the review process from the Fish and Wildlife Service perspective. Avoiding wetlands, that helps you with your Clean Water Act reviews anyway. And then other known bird concentration areas. And this is important. You know, wetlands tend to concentrate birds. Avoiding ridgelines and coastal areas is also important. And I know, for example, for Michigan, the Fish and Wildlife Service Office will put your tower project through a more intense review if you are near wetland bird concentration area on a ridge line or within the coastline of the Great Lakes. So that's an example of just how you can streamline your own review. The next slide, or next slide. Avoiding, and this is a lot about avoiding vegetation disturbance and species. So avoiding vegetation removal or maintenance during the bird nesting season is important. When are those time periods? IPAC, as Debbie mentioned, and then Avian Knowledge Network, or AKN, can help you specifically with the timing of when nesting is. Another opportunity is to conduct nest surveys to kind of clear the area. Yes, 5 days before you're going to clear the site for a tower's construction. If you were to do a nest survey 5 days prior to that, less than or equal to 5 days, so you know that there are no nests in that area, or hope there are not. The next bullet there is to avoid protected species, key habitats, prairie and sage grouse leks. So Debbie talked a bit about avoiding protected species, and also those key habitats are important. Does anyone know what a grouse lek is? Any grouse hunters out here? Okay, a grouse lek is pretty cool. So the grouse, prairie grouse and sage grouse, actually, they're like big chickens. Like we have prairie chickens are considered a grouse and a prairie grouse. And they do a springtime dance where all the guys get together in the middle with the best guys in the middle and the subpar guys around the edge. And they literally dance and they jump and they make loud noises. And the females are attracted into this, and they come around the edge and work their way to the middle for the superior guys. And then that's where mating occurs. And those leks are very sensitive and special. And I always think about, when I think about leks, I live in a college town, and I think about like the bar scene on Fridays and Thursdays. And the guys are not like, they're like in sweatpants, and the women are dressed up. I'm like, this is not a lek at all, you know? And but it's a really cool, but yet sensitive resource. And if you think about how that habitat could be changed. So if they're a prairie grouse and you put a big, tall structure out there, it's not going to be the same habitat for them. We may say it's a prairie with a tower. It's not that different. But if you think about how their perspective, or how our perspective would be, would we consider a cave to be our home? We could live there, but does it feel like home? Would we select it? Probably not. And so it's kind of similar with leks. It may still be a prairie with a tower next to it or a power pole next to it, but it's different to them. And sometimes they'll avoid tall structures in those areas. So that is something, and the state governments tend to work with the grouse leks just based on the Migratory Bird Treaty Act and protection, with the exception of some endangered grouse. But oftentimes you're working with state governments to avoid those grouse leks. I also wanted to add rookeries. Anybody know what a rookery is? Yeah, rookeries are pretty cool. Florida's kind of known for their rookeries, or the southeast. Huge areas of herons and egrets, and you can see them from Google Earth. You can see all the white bodies. Wood storks, you can see them on the nest. Pretty cool. And those rookeries are also sensitive areas that we'd want to pay particular attention to when we're selecting a site for development. And if you can avoid some of those areas, you streamline and move your approval process faster. Okay, so, and then buffer eagle and hawk nests by 0.5 to a mile. I have tried, even from when I was at the FCC and then from the Fish and Wildlife Service perspective as well, to try to narrow that number down. I understand from the industry perspective, they're like, which is it? I get that. And within our regions, within the Fish and Wildlife Service, we understand that biology is not cookie cutter, and some species, like the bald eagle, is less sensitive than the golden eagle. And so we do need some flexibility in that, and I encourage you, as much as I would like to give you guys a nice firm number, I do encourage you guys to work with your field offices to understand what the need is in the specific area that you're working. And then I also put in prevention of the introduction of invasive species is important, and plants in particular in some of these developments and projects. So next slide, please. Okay, so using motion sensor security lighting for both new and existing. This was never a big a big deal for the industry. Most people are either using no security lighting or motion detector lighting. And so I was happy when I worked with the FCC to learn that the industry is this is kind of the norm. And it was it was never a big ask. And it was rarely even an issue at all. And so motion security lighting is a good thing so that we are, again, reducing those steady burning lights, those lights that are constantly on, thereby reducing the bird attraction into a site. And these things will help you reduce your timeline for having projects reviewed by the Fish and Wildlife Service. And another thing that I'm just going to throw out there is the East Lansing Field Office is one in particular that I'm aware of. So Michigan, they work with the tower industry to say, when you come to them with a tower project and say, I'm proposing this project, can I get some review on it? Oftentimes they'll say, yeah, this is our opinion on this site. How about your other towers and your lighting? And they'll kind of incorporate that into the review just as a question. Are you guys working to reduce your non-flashing lights, your steady burning LA10s, your side markers on your other projects? So if Verizon, or I shouldn't name names, but if an entity, Sprint, Nextel, whomever comes in, they will reach out and say, how about your other towers in our state? How are you doing with extinguishing those side marker lights? So that would be another nice thing. I'm just suggesting to add to your initial informal consultation to say, just so you know, we're doing this, this, and this with our existing tower projects and trying to reduce our bird collisions. So again, that wraps up what I was going to speak about, and I'm not sure if our AV guys have been able to bring our tower video up. I don't know if they're even listening to me.
No, but we have a lot of questions. Maybe we can jump into questions.
So that would be good too. But I encourage you, I'm just going to, that's what it looks like. And if you click on that link, there is a hyperlink in there, but apparently the audio or something is not working. So, but it's a cool video. So it's Win-Win Communications Towers, or just Tower, Win-Win Towers, and you can get a really nice video featuring Jimmy Miller of NATE and Richard Hickey of Vertical Bridge. So two good guys. All right, so these two links that you see here are to the recommended best practices, which I've just basically gone through, and I've left about 30 copies on the back table if you'd like to pick those up. It goes into more detail about what I just went through. And then also the second link there is to our trusty FCC, and I hope that link still works. I should have double-checked it, but that is and it's hard copy on the back table there of the steps to go through to extinguish side marker lights or to reprogram. FAA, FCC updating of the database, go to the tower, flip the switch. All right, so that's all I have. There's my email address. I ordered cards for you guys today, and they didn't come in time. I'm sorry. But my email address is _, not a dot. I like the dot better at the FCC, but I have an underscore now, and at fws.gov. So I welcome any questions that you have.
Great. Thank you very much, Joelle and Debbie. So the first question's for Debbie. If the informal biological opinion from the consultant is no effect on federally listed species on the IPAC, but adjacent habitat may be present for migratory bird species listed on the IPAC, and the consultant has reached out to U.S. Fish and Wildlife Service, but is unable to receive a response, what is the proper way to close out the review?
Thank you. As long as the tower is, less than the 450 feet, you can certainly, if you want a more a biologist's opinion, you can certainly contact me, and I will review the project itself and see, the potential impacts to migratory bird species. But as you know, the requirements for an EA are towers that are above 450 feet.
Great, thank you. The next couple questions are for Joelle. Joelle, could it be considered a take if a bird dies and you did not change to blinking lights?
That's a timely question. So it is my understanding that it has never been enforced because we have had a discretion. It's been up to the discretion of the law enforcement officer when it comes to Migratory Bird Treaty Act. Technically, it is a take under Migratory Bird Treaty Act. The M opinion, I'm sorry, I'm getting kind of into the weeds here, but there was a short period of time when it was not considered a take because it was incidental. But that has been since changed in the last couple of years, last year. And so it would be considered a take. It is up to the discretion of the law enforcement officer, and I'm not aware of that ever occurring at a communications tower, actually. But it is, things are changing, actually. And we are, the U.S. Fish and Wildlife Service, and part of the team that I work with, I don't work directly with it all the time, but I am pulled in for the communications tower issues regarding the proposed revising of the Migratory Bird Treaty Act. And that is what it is right now. It's proposed, and nothing is formal yet. Well, it is formal. We're working on the document, but it is not in the Federal Register yet, as far as the proposed change of rulemaking. So, and what, without getting too much into the weeds of the new Migratory Bird Treaty Act or the proposed Migratory Bird Treaty Act, there will be aspects of the need to extinguish those side marker lights. There will be a time frame that's included that I believe is fair. There will be opportunities for those towers who may not be able to have their lights extinguished, and there are some out there that the FAA very rarely, I think I have heard of 2 situations where a tower owner has said, you know, I tried to extinguish my side marker lights, and because of X, Y, and Z, the FAA did not allow that. It's been like 2 cases out of, thousands. And so, but it does happen, and we're working in, opportunities for people to still be in compliance in those situations. But in the future, I would suggest that people look to the future for how the take will be interpreted when it comes to lights and communications towers. We're hoping by the end of the summer. I guess we're kind of at the end of the summer. That was our initial deadline, or our initial goal. By the end of the year, I think we're going to see something more formal for people to review regarding communications tower. And just know that I have worked with the industry now for 19 years, and that the Fish and Wildlife Service is making use of my experience with the industry, and I am an advocate for things being fair and doable for the industry. That's how we're going to get it done, just by things being doable. So know that.
Thanks, Joelle.
Yes.
One more question for you. How effective are anti-perching devices and other bird diverters, and which do you recommend?
Feel free to jump in on this as well. So anti-perching, and then, did you say nesting at all?
Bird diverters.
Okay, bird diverters, okay. So, yes, there is, and feel free to jump in. You've been working on these issues as well. I've heard mixed reviews. It is challenging. So I'll start with the bird flight diverters. There are challenges with using the bird flight diverters, and I work closely with Richard Hickey of Vertical Bridge and ask him stuff like this all the time. He's kind of my go-to guy. Like, is this going to work? And Vertical Bridge has put a lot of effort into installing bird flight diverters, and we don't have data. And be completely transparent, we do not have data at communications towers on whether they work or they don't work. We have a lot of data on utility lines, and they work. They work on utility lines, but on guy wires, we just haven't collected the data. But it would be really nice to do that. But one of the challenges with using bird flight diverters is that in some climates where you have snow and ice buildup, they can inch their way down the guy wire, and then they're all at the bottom. And you've spent a lot of money, and they haven't worked. But in most environments, in most climates, I do believe they work. The data on utility lines suggests that they work, and they do stay in place as needed. It's just in specific situations where we have snow and ice buildup that they can kind of inch their way down. So that, I would say bird flight diverters do work, and and the Fish and Wildlife Service generally recommends them in sensitive areas. We talked about wetlands. We talked about bird concentration areas. Those, in my opinion, serve as the best opportunities to reduce bird collisions using bird flight diverters. So that was bird flight diverters. Nest deterrence. That's tricky. These birds are determined. And there are some designs out there, and as a federal agency, I can't recommend any name brands, but there are some that because we need to think about access for a climber as well, right? Safety and access for a climber. And we can't interfere with equipment that the tower is intended to support. And we also need to keep the birds out. So it's a complex situation, but there are a couple nest diverters the designs that kind of look like trees up on the top, so they have wires, cables coming down that allow the tower climbers to safely unhook them and climb in to this cone of cables. That tends to work well. What was it? For big birds, yes. I believe that. Yes. Oh, now I'm protected. You've built a cage for me to nest in. Okay. And it has been a challenge, and I understand. You know, we in our agency we kind of laugh. We laugh in a kind of a painful way because bald eagles are doing so well, and it is a huge conservation success story. But this industry struggles with the birds nesting on towers and then really restricting when you have access to the towers. So again, I'm doing my best to work within the agency to help streamline access and permits to get into some of those sites. But nest exclusion devices, they can help, but it's not fail-proof for sure. Yes. Yes.
Thanks, Jill. I think we're running out of time.
Okay.
We want to try to take one more, do one more question,
Thanks.
which I'm going to take. So we got a question about the may affect not likely to adversely affect determination and when to submit an EA. So the Bureau reviews environmental concerns on a case-by-case basis, so we can't provide a definitive response without specific facts. But in general, if the U.S. Fish and Wildlife Service concurs with the may affect not likely to adversely affect determination without imposing conditions, and there are no other triggers that would require filing an EA, an applicant does not need to file an EA. Conversely, an applicant should file an EA when the U.S. Fish and Wildlife Service assigns site or project-specific conditions to its concurrence that the project is not likely to adversely affect a protected species or habitat. So that was the last question we were going to take, and I think now we can take a break. Do you want to?
Thank you, you guys. We'll be back. I think it's scheduled, we're going to be back at 3:30. Is that right? 3:30. So everyone, enjoy your break, and we'll be back in just a bit. Thank you. Okay. Thank you. Thanks again, everyone, for gathering back. Okay. Great presentation. Thank you, Debbie and Joelle. Thanks again. It was really interesting. And now we're going to turn to a presentation on an overview of the antenna structure registration requirements. Michael Smith, Program Analyst of the Competition and Infrastructure Policy Division within the Wireless Bureau, will be presenting. Mike, I'm going to hand it over to you. Thank you.
Hey everybody, how you doing? And welcome to After the Break, the After the Break session. Invited a few more empty chairs than I remember this morning, but we'll see if I can't make this interesting for you. We're gonna have a little chit chat today about ASR. And as you can see from the first one, that's me, Michael Smith, Program Analyst. Next slide, please. We're gonna talk a little bit about ASR, as you might well imagine. The Federal Aviation Administration requirements, and some environmental requirements. Next slide. Okay. ASR is the Tower Registration Database, and it stores the following information for certain tower structures. And so it stores tower owner and contact information. And by the way, if you're a tower owner, please keep the contact updated. It's very important. Sometimes we struggle with that. Also, some antenna structure information, the type that you would think about, structure type, location, the height, the lighting, and the FAA study number and issue date. Now, keep in mind that most people have it when they first do their ASR application, but it doesn't technically need to be there until the Part 2 certification, but most people have it done ahead of time, because it's important that you make sure that the stuff that's in the FAA study matches what you put in your local notice and what's in ASR. Otherwise, you could be doing this stuff twice. Okay, also in there will be NEPA-related info like public notice dates, environmental assessments, if it's required, exceptions to the environmental notification process, waiver requests, decision documents, and other related attachments. Also in there will be a record of filing dates and changes made to the application. That'll be in the history section. So you can track what's been going on with that particular application. It doesn't collect frequency information. I think that's ULS. So the applicants must complete the FAA study number and issue date, but again, that's for the part 2, and must do the notification process unless the waiver is granted. Now, the important takeaway here is that construction may not begin until ASR is granted. No clearing, no mowing, no, I accidentally put in a road, or I accidentally put in posts for my guide wires. I woke up one morning and they were there. None of that stuff. Just wait till the stuff is all, the ASR is granted, and then you can go forward. Next slide. Okay. FCC rules require ASR when notice to the FAA is required due to physical obstruction. And it's required under 2 circumstances. If it's over 200 feet, or it fails the slope test, which means it's a flight path somewhere for a nearby airport or helipad. Now, to check that, you could use the FCC's TOW-AIR tool or the FAA's Notice Criteria tool. Now, there are commercially available tools, but I would stick with the FAA's Notice Criteria and ours. Okay, now, if ASR is required, you must provide a valid FAA study number associated with a no hazard determination. And that's important, because if you have a hazard determination, you're not going to get a registration. It's no hazard. That doesn't mean that there can't be lighting, there's painting and lighting, but there are things to mitigate the problem, so it can be a no hazard if you do X. Next slide. Okay, in 2011, the Commission adopted the environmental notification process to ensure that the environmental effects of proposed communication towers are considered prior to construction. This might sound familiar. Unless an exception applies or waivers granted, the environmental notification process applies to all new tower applications and certain modifications. Next slide. Okay, here we go. This will give you the general rundown of the overall process. Okay, so people will submit a Form 854 to get the process started, and it'll be partially completed so they can get the ASR application number that they can put in the local notice. And you also will set a national public notice date to begin on or after the local public notice date. That's important. Local first, then national. Otherwise, you'll have to redo it. And just remember, when you do the national notice, it has to be a weekday. Can't be a weekend or a federal holiday. Okay, now the national public notice date commences the 30-day comment period to give public opportunity to file a request for further environmental review. And that's why national notice date is so important. If you end up having to change it for whatever reason, that puts you back and you have to do the whole 30-day notice process again. Now, if the FCC receives a request for further environmental review, WTB will determine whether environmental assessment is required if one was not proffered at the start. Again, the submission of an EA will restart the 30-day process because the public needs the full 30 days to comment on what's going on, which is, i.e., the EA. And just as an aside, if you make substantial changes to an EA, if you put one in, do the 30-day notice, and then have to make substantial changes for whatever reason, that will also start the 30-day notice because we want people to be able to comment on the actual EA itself, the final one. Okay, so the pleading cycle must conclude prior to moving to the next step, to the part 2. And so however that happens, whether it's either a dismissal or we provide a FONSI. So once all that stuff is completed, then you'll start the part 2. You can do part 2 certification. You can put in your FAA study if you did not do it previously, and then you'll certify that the tower has no significant environmental impact. But we'll discuss more of the part 2 in a bit here. Okay, next slide. Okay. There are some exceptions, 7 of them, well, 8 of them, to the notification process. And so not everybody has to do the notification if you can get to one of these 7 exceptions, if you qualify for it. One is for notification only, simple stuff, change in contact, dismantlement, change in ownership, that sort of thing. Second is a reduction in tower size or increase in height that is non-substantial. Now, for those of you scoring at home, it's Part 1, Appendix B, 1E, 1 through 3. And that's the definitions. But quickly, it's essentially 10% or 20 feet, whichever's greater, plus a couple notes about bits on the bottom of the tower, but we'll get to that. Now, occasionally, and I emphasize occasionally, we grant an emergency waiver. But please note, the emergency waivers are for not stuff that's avoidable or foreseeable. So just think national disaster. It doesn't cover oopsies and doesn't cover we forgot, none of that. This is just natural disaster kind of stuff. Now, even if you get one of those, you'll probably have to do notice afterwards. So now, just an aside, these are merely exceptions. If you don't qualify, it doesn't mean you can't get an ASR registration. It just means it's going to take a little longer. That's all. Next. Okay, replacement tower. To meet this exception, you have to be in the same geographic location, and I emphasize that. You can't not require an EA. They can't use less preferred lighting style than the original tower. Does not involve that substantial increase in height, and doesn't involve construction or excavation more than 30 feet beyond the existing antenna structure property. Now, here are the notes that I referred to earlier, the bottom couple. While less common, a substantial increase in size would disqualify a proposed tower from meeting the replacement tower if the replacement tower involved the installation of more than a standard number of new equipment cabinets for the technology involved, not to exceed 4, or more than 1 new equipment shelter. The other one would be more than, the new antenna structure would be more than 20 feet wider or more than double the width of the existing antenna structure at any height along the tower. Those are rarer, but they're there. And again, that's in the definition. Next. Okay, temporary tower exemption. These are usually they're cows or sail on wheels. And to qualify for this particular tower, you have to have, it can't be in place for more than 60 days. You have to talk with the FAA and get and make sure that it does not require marking or lighting. And so even if it's not lit, but there are flags on it, you still would not qualify. There's no marking at all. And you'll need an FAA no hazard determination. But that's with everything. It has to be less than 200 feet in height and involves no or limited excavation. Now, if you get one of these, Once you take it down, you have to wait 30 days before you can put something back, another temporary tower that has substantially the same service area. So you can't just sequentially put these out. Next. Okay. So some of the information that's required in the for applications that require notification. It's the usual suspects that you would think. Ownership information, name, address, phone, contact information, name, address, phone. But again, please keep that updated. That's important. The location, the height, and type of structure needs to match the local notice and the FAA. You can get yourself in trouble if they don't. You have to start redoing stuff. The proposed marking or lighting, whether another federal agency has taken responsibility for the environmental review, the national notice date, and again, the national notice date, business day, not weekend or federal holiday, and whether an EA is included. Next. Okay. Again, the no hazard determination is not required to do the original bit, right? You can get your ASR application number without the FAA study number, but you can't do part 2. And so the lighting and marking description contained in both the local and public notices must be accurate. If you say in the local notice, there's not going to be any lighting on this, but the FAA says, oh, I beg to differ, and they give you no hazard determination, but it has to be marker lit, you got to redo the local notice. And so if you redo the local notice, you'll have to redo the national notice because the national notice has to be on or after the local notice. That's why it's important to get this stuff straight the first time. And again, the ASR won't be granted without the valid FAA study number. Okay, next. Okay. National public notice, the timing part. Here we go. This is important. National notice date is required for filing an ASR application that requires environmental notification. On the date the applicant requests, the Commission will post an application information on its website. It will remain there for 30 days. Gives people a chance to comment on it. The applicant may change the national notice date to any date in the future as soon as the next business day. So for whatever reason, you find out that the local public notice was defective for whatever reason and you want to adjust and put the national notice date ahead, you can do that. But it has to be, like I said, a business date. But you can't go backwards. So you can't backdate a national notice date that's before the current date, because sometimes people will put it out ahead of time, say, okay, well, I think it'll take a month to do public notice, for local public notice for whatever reason. It only takes a week. They want to move it back, but they can only do it to the current day. They can't do it back past that. The national public notice is also important because it sets the pleading cycle. After a comment or a request for further review is received and the applicant wants to move the national notice date to another date, you have to remember to notify all the parties pertinent to that tower. All the commenters that have commented all have to be notified because they're likely to comment on the news, anything that's added. Okay, next. Okay, where to find the national public notice? Okay, like we said, it provides interested persons access to the information, and that web page address is where you find it. It's basically on the bottom of the ASR homepage. Okay, next. Local public notice. Okay, local public notice date is not required up front in the application, but you got to have it before you're done. Local notice must be published before the national notice or on the same day as the national notice. And if you have to redo local notice, you got to also redo national notice. Okay, well, what goes in it? Okay, the ASR application number goes in. The geographic location, structure type, height, anticipated lighting for the proposed new or modified structure. Now, some people will try to guess at the lighting. They think it's none, but if the FAA says there is, that's a problem. So just be careful with guessing. Make sure it matches the FAA study. It also needs to include a statement that interested persons may access and review the application online at that link by entering the Form A54 number, and a statement that interested persons may raise environmental concerns about the proposed structure by filing a request for environmental review online. Now, again, I emphasize it's got to be environmental concerns that they're being raised. Next. Okay. Some, to try to save time, will try to combine local public notices. There's the two. There's the one for the ASR environmental notification process notice, and then there's the notice for the Section 106 National Historic Preservation Act review. You can do it both in the same, but you have to make sure that everything is in there. All the requirements for both are in there. Section VC of the NPA requires this stuff to be in the local public notice. Location, including street address, description of the facility, including type and height, instructions on how to submit comments regarding potential effects on historic properties, and the name, address, and phone number of a contact person. Now, local notice, beware of the local public notice websites. Public notice must be specifically local and well-known in that area. To quote the rule, publication in a newspaper of general circulation and other appropriate means, such as through a local zoning process. So you're going to try to find the paper that's most local, and then you're most likely to get the largest amount of attention to that. One that is in a town a ways off that may or may not be distributed in the local area likely won't be sufficient. So just get it as local as you can, the local newspaper, or where the zoning board would post stuff. Now, there are websites. I don't want to tell you what to do, but I would shy away from them, especially if they're pay websites, because not everybody would have access to them, and therefore it wouldn't be effective local notice. Next. Okay, request for further review and the pleading cycle. As we said, the pleading cycle is based on the national notice date. And once a request for further environmental review is received, the applicant should inform the Bureau and any requesters immediately if it wishes to change the national notice date for whatever reason. Maybe they need additional time to adjust their EA, or now that they think they now need to do an EA, whatever it is. So once the national notice date is set, the pleading cycle is 30 days from the national notice date. That's how long people have to comment. After that, the applicant has 10 days to respond in their opposition. And then after that, the requesters had 5 days to reply to that, 5 business days. And so that's essentially the business cycle, the pleading cycle. Okay, next. Okay. The request must state why the interested person or entity believes that the proposed antenna structure or physical modification of antenna structure may have significant impact on the quality of the human environment. And that's what we're looking at. Sometimes we get some extraneous stuff in there, but we're looking at the impact on the quality of the human environment. Or if an EA had been submitted, why that EA does not adequately evaluate the potential significant environmental impacts. Now, all these comments must be submitted electronically. If you can't do that, you can submit them by mail, but you have to also submit a written petition for waiver under 1.1304B. Again, and lastly, you must set forth in detail the reasons for supporting the requester's allegations. Be as specific as you can. We can only go off of what we see. Okay, next slide. Okay, part 2. It may not be submitted until all environmental review is completed. So if people have done comments, all that process has been done. It's either been dismissed or a FONSI's been submitted. All that stuff is done. If an EA's been submitted, you know, a FONSI's done or requests have been resolved, all that stuff's handled. When it's ready for part 2, you could just hop online and it will tell you that it's ready to go for part 2 certification. And that's how to do it. But again, don't certify in part 2 until you're supposed to, because you're attesting that you've done all of this stuff has been completed and that there's no significant environmental effect. So just wait until and do that only when all this stuff has been handled. Okay, next slide. Occasionally, you got to do notification more than once. For example, defects. Defects in the local notice, you'll have to do both of them again. Certain amendments to pending ASR applications, we'll cover that here in a second, and certain modifications to registered towers will require new notice. Next. Okay. Amendments to pending apps. New notice must be done for all other changes to the physical structure, lighting, or geographic location data. That's why it's so important to get this stuff right when you do the local notice and the FAA study. So any change to the structure type or coordinates, increase in tower height, and change to a less preferred lighting style. Adding an environmental assessment to the application also requires new national notice and may require new local notice. No new notice is required for reductions in height, lighting that's either removed or goes to an equally preferred or more preferred lighting style, or stuff that's just administrative. Next slide. Okay, for existing registrations, it's the difference between a major and a minor modification. For major modifications, those are the ones that require new notice. Major modifications are a substantial increase in height, again, 10%, 20 feet, whichever is greater, plus the assorted stuff about the base of the tower. You're submitting an environmental assessment now, or you're changing the lighting to a less preferred lighting style. Minor modifications are administrative changes, update to the FAA study number, correcting coordinates under limited circumstances, as long as the physical tower is not moving anywhere. Lowering the overall height, and changing the registered lighting to a more equally preferred lighting style. Now, just remember that these are a bit like snowflakes. So if you have any questions, you know, just contact CIPD, and we can answer any questions that you have. But feel free to do that. Don't Next slide. Okay. Some are licensees, some are tower owners, some are both. So for the licensees that are submitting a Form 601, some of the things you need there are the ASR number. But if you don't have the ASR registration, that's okay if you have the ASR application number if three things apply. If you have the FAA study number and the no hazard determination, if you have the local notice done and the national notice is posted, then you're free to submit the 601. And I think that's it. So generally speaking, how long did I take? Not bad at all. But just remember, try to make sure, this will save you tons of grief, make sure that things match. That local notice, FAA study number, and all that stuff matches, so you won't have to go back and forth, and we can get these things through as quickly as you can for you. I think that is it for, unless we happen to have a question or two.
Thank you very much, Mike. We are running out of time, but we'll have two questions for you. The first one, can you still qualify for tower replacement, for the tower replacement exception, if you change your tower type, but remain in the same location? For example, you go...
No. That would be N followed by no. Yes. No, it has to be the same. A replacement is a replacement. You know, if you eat somebody's, Hershey bar and they bring you Tic Tacs as a replacement, nah, I'm having a fit. It's not a replacement.
Thank you, Mike. The second question, is it still a requirement that the newspaper be printed, or can it be online only? I assume that refers to the local notice requirement. With so many newspapers failing, it is becoming harder to find newspapers in smaller towns.
If it's a local newspaper, whatever the general dispensation is of that particular newspaper should be fine. And so whether it's printed or whether it's online, we just require access. We want to make sure that people know what's going on. So if they want to, they can comment on it. That's the point of that rule.
Thank you, Mike.
Oh, I didn't get a little, I didn't get my... Can you hold that up for everybody? Thank you. Thank you. Now I feel like, all right, I appreciate that. And as they say, back to Garnet.
Thank you, Mike. Excellent presentation. Okay, importantly, it looks like someone left some glasses in the women's bathroom. So they look like much nicer glasses than I personally have, so I want to make sure they don't lose them. Excellent. Okay, so we are starting our final panel today. And to carry forward our theme of birds, I thought I'd tell a joke. So why did the bird get in trouble in school? Because it was caught tweeting on a test. Okay, you guys, I know. It was consistent with the bird theme here. Okay, so we're starting our last panel, which will talk about streamlining multi-agency environmental reviews for broadband projects, a very hot topic in today's world. Okay, I'm pleased to introduce Jomar Maldonado, Director for Nhpa at the Council on Environmental Quality, who's here in person, Andy Belikowski, Director of Environmental Compliance and Federal Preservation Officer at NTIA and FirstNet, who's participating virtually, and Jill Springer, the FCC's Federal Preservation Officer, which, as you know, Jill is here at the table. And so I think I'm handing it over to Joe Marr first. Thank you for coming in person as well, Joe Marr. It's nice to meet you in person.
Nice to meet you as well. Thank you. And I appreciate the invitation that FCC extended me. I know Carrie from previous experience over at DOT, and I've worked with Jill, and I see some familiar faces as well around. So I really appreciate the chance to come and talk about what are the exciting things we're doing in the broadband space. My name is Jomar Maldonado. I am the director for NEPA, the National Environmental Policy Act, over at the White House Council on Environmental Quality. So my agency is a small agency, but we do a lot of influence, and we develop the regulations that all the agencies have to follow. We set the stage with those regulations, and each organization, each agency has to develop their own supplemental procedures to comply with the National Environmental Policy Act. And some of the things that you have been hearing about this over the day relate to that, and how FCCs comply and develops a program to make sure that there is compliance with NEPA. In my shop over at CEQ, I have the pleasure to work on NEPA issues as well as infrastructure elements and environmental review and compliance requirements like Endangered Species Act. And you all heard Migratory Bird Treaty Act. And to some extent, we work hand in hand with Advisory Council on Historic Preservation on matters related to historic preservation. So what are we doing in this administration regarding broadband and issues related to NEPA? In this administration, we set out with a very clear roadmap with the executive orders that were issued at the very outset of the Biden administration. There were two important executive orders, 13990 and also 14008. The very first one asked us, as CEQ, as well as all the agencies in the executive, to look at regulations, procedures that were developed in the previous administration, do a review of those requirements, and determine whether they needed to be changed to account for climate change, the climate crisis, environmental justice, which is a very important role in this administration, as well as turning into clean energy and making sure that we're considering the environmental factors in decision making. For us, for CEQ, that meant that we had to go back to our regulations that were issued in 2020, those that I mentioned before, which are the basis for all the agencies, and take a fresh look. Determine if there are things there that needed to be amended, things that should be retained, things that could be improved upon. It also asked us under that executive order to look at climate change and look at the guidance that we've been issuing to agencies on how to handle climate change, how to deal with GHG emissions for federal projects in the NEPA review process. And then the second executive order is equally important because it asked CEQ to look closely at what we were doing in the environmental justice context. Are we providing the benefits that we needed to communities that have been underrepresented and underserved for years? Those include not just low-income populations and communities, but included minority populations and communities, and something very important in the broadband context, rural communities as well. It asked us to make sure that we were working through all the other agencies, together with the agencies, to achieve a goal of 40% of benefits flowing through those underserved communities. To do that, we created an initiative called Justice 40. And this is an initiative that is looking at the benefits, at the actions, at infrastructure that's being developed, that is being either developed with federal funds and dollars, but also through federal authorizations, allowing things to happen, and make sure that those agencies have markers, have performance measures that achieve the goal of 40% to those communities. We at CEQ have a leadership role in that context. We have established a White House advisory committee with members of environmental justice communities to help us out. We have established a mapping tool that helps agencies figure out where those communities that are underserved are so that they can plan ahead and plan their projects and activities. And we also have been working on revisions to environmental justice material. How do you consider environmental justice when you're doing NEPA? How do you take into account those impacts into your project development? On the first executive order, we've been engaging, the Council on Environmental Quality has been engaging in a revision to the NEPA procedures. We have scheduled to do this in a two-phased approach. The first phase is actually went into effect in May, and it focused on three distinct aspects, making sure that agencies can go above and beyond what CEQ requires. So CEQ is the floor, the regulations is the floor, so agencies can incorporate the benefits to the environment and to communities into that process, as well as clarify the question on cumulative impacts. This is something that has been debated for years, to what extent we consider cumulative effects, how far away into the effects analysis do we have to go, indirect effects, and in the climate context, the issue of upstream and downstream impacts and how do we consider those. So we clarified that in the phase one, and now we are undertaking a phase two, and that's very exciting from our end. The regulations had not been revised in 40 years. They actually have been in the books for 40 years. The previous administration took a shot at it. We are also looking at it as well. So it's a big endeavor that addresses a lot of infrastructure in this country, and also including the broadband side. And then we've also targeted that process to end up in a notice of proposed rulemaking that will likely come up now in the fall, hopefully early fall, so that people can see it and comment on it. We're getting geared to it. So I welcome any input that folks would have on all aspects of that regulation. Concepts like categorical exclusions. What should be categorical exclusions? How should agencies rely on each other to utilize those? If there's a program that NTIA is pushing, is that something that another agency like DHS can use in the categorical exclusion context? Environmental assessment, EISs, and so forth. In addition to these various efforts on environmental justice and on the CEQ regulations, there's one big effort that we are monitoring and we're pushing that relates specifically to the broadband context and to the question on how do we streamline multi-agency review processes. This is the Biden administration's permitting action plan. This is basically a guide that we have issued to the federal executive branch on how to streamline environmental review. How do we make environmental review processes more efficient for all sorts of infrastructure projects? And the impetus of this was the bipartisan infrastructure law, which we call the Infrastructure Jobs and Investment Act, IIJA, as well as the more recently released Inflation Reduction Act. There's a lot of money going out for the agencies, a lot of funding for broadband, for example, in the context of NTIA, and my friend Andy is going to talk a little bit more, I imagine, about that, but also calling in to agencies that deal with permitting. For broadband, it's not just about the money. Where's the money to get the projects in, but also how do we engage with agencies that have permitting responsibilities? The Army Corps of Engineers, the Bureau of Land Management, Forest Service, when you have to go through federal lands. So we laid out a plan with 5 elements in that plan. One of them is ensuring that there is interagency coordination, that we are getting together as agencies and identifying what are some of the problems that we have that we have identified in the field regarding the deployment of different types of infrastructure. We have one for transportation. We have one for offshore wind, for clean energy, and we do have one for broadband. And this is not unique to this administration. previous administrations have tried to tackle this issue. They have developed some ideas, and those are getting over to this group, working together with entities like NTIA, DHS, working with the land management agencies, Bureau of Land Management, Forest Service, as well as GSA, and also the Advisory Council on Historic Preservation, to identify ways that we can make the process better. And what does it mean from a practical standpoint? It means two things. One, that we are monitoring big projects, big ticket items, making sure that we're meeting schedules, that we're establishing those schedules to accomplish the important delivery of this infrastructure. We're also not only focused on those big projects, big ticket items and issues, but we're trying to leverage as much as we can with existing authorities. What does that mean? That's a lot of mumbo jumbo, but what it means really is that if we're talking with Achp, let's see if we can identify more programmatic solutions, programmatic approaches, programmatic agreements that could be developed, or other areas that we can explore. And Achp came in, talked, I believe, a few minutes about their initiatives and what are the great things that they're doing. But we're also trying to push that same model to other agencies like Fish and Wildlife Service. You know, how do we get Endangered Species Act a little bit more, work through a little bit more streamline, or get into more efficiencies into that process, identifying issues related to migratory birds, for example. And one of the big ones is realty. You know, how do we get through federal lands in a way that is efficient, that it doesn't take too long, and it actually meets the goals of the different laws that they have to deal with for land management in particular. One of the things that we're going to try and do is leverage a unique body that was created in 2015. It's called the Federal Permitting Improvement Steering Council. We call it the Permitting Council, which is a body that's intended to streamline all of these efforts and to monitor. Monitor, make sure that we're meeting deadlines, make sure we're adhering to the requirements, but also we're improving benefits to communities, and we're actually achieving the goals of better broadband, better infrastructure, better roads, better bridges for the United States and the nation. That body has the ability to track projects. It has a permitting dashboard that you could put in projects that meet certain thresholds, like environmental impact statements, and make it very transparent where things are in a particular time frame. And also to hold us agencies to the fire if there's a missing timeline or a missing goal or objective that we have laid out at the outset for a particular project. You know, one example that I have on that work is right now we're working with California Department of Technology, which has a middle mile project trying to push 10,000 miles of broadband throughout the whole state. And we're using that body, using that coordination, we're trying to bring all the parties together, bring in different agencies that are going to be involved in that process of laying that broadband and laying all the work that's needed, like the Department of Transportation. A lot of the lines are going to go in the roads to make it easier, but also working with Fish and Wildlife, with Forest Service, BLM, Department of Defense, the Department of Homeland Security, to try and get it all done within the next couple of years as required. So that's kind of an example of a major project that we're all monitoring, trying to establish relationships at the state level and also at the national level with each other, so that we can make sure that these projects happen in a quicker time. A couple of things to mention before turning it to Andy. That permitting action plan, which is on the web, it's easy to follow, just Google permitting action plan. It lays out the interagency collaboration efforts that I mentioned, but it also lays out other markers, other things that this administration is going to be focused on. One of them is making sure that we are setting goals and timelines for activities and projects, so that we can deliver on time and efficiently. Another one is to help states and local communities to understand environmental requirements and help them help us go through the process as quickly as possible, and to the extent that is feasible, provide resources so that they can help in that review process. In not only state and local communities, but also with tribes, which I know is a big issue in the context of broadband, as well as in the context of telecommunications in particular. And then building resources, creating resources at the agencies, utilizing and leveraging all the different statutory authorities and funding mechanisms that we have to give to those agencies that need resources to be able to go through the process as efficient as they can. So those are the kind of the general concepts of the permitting action plan. I welcome folks to look into that permitting action plan. We are requiring agencies to develop implementation plans, otherwise identify how they're going to develop that plan, how are they going to stick to it, what's their programmatic approaches and solutions, what are the major projects that they're looking at, and lay it out in that implementation plan for us to follow and make sure that we're all meeting that implementation plan. And soon we will be issuing guidance at the Executive Office of the President level that lays down more details on what we expect with the different agencies in this coordination process. So those are some of the examples that we're pushing for. Some of the things that we are looking forward and excited about to implement in the next couple of years. Starting this year, we now have a lot of funding from the Inflation Reduction Act that we can push the agencies to help out in the delivery of this all this infrastructure and this network, and something that I would want you all to look into, search, and be participant as well. There are a lot of opportunities for you to provide your input as an industry, but also individually, on how we can improve the general process, the environmental review and permitting process for all. So now I'm going to turn it to Andy. If Andy's there, I'm going to leave it to you, and then leave more time for questions too. Andy?
Thanks, Jomar. Hi, everyone. Andy Bilikowski. I'm speaking about the FirstNet Authority and NTIA and their roles in telecommunications and broadband deployment. So just to give you, and I'll do this for both FirstNet and NTIA, just to give you kind of an understanding of kind of who we are, where we came from. So FirstNet Authority, the First Responder Network Authority, we came about based on the Middle Class Tax Relief and Job Creation Act of 2012. That act mandated us to develop, deploy, operate, and maintain a nationwide public safety broadband network, what we call the NPSBN. The NPSBN is the first and only nationwide, that's the key part, nationwide telecommunication networks that's dedicated solely for the use of public safety and first responders. How we kind of tie into the FCC is that in 2012, the FCC, in accordance with the Act, granted us a license to use block spectrum. And as you'll see in the next slide, that's important because what that created is, as a result, the FirstNet Authority is both an independent federal agency as well as an FCC licensee. Next slide, please. As far as our Environmental Review Authority, as I mentioned, as Jomar mentioned, NEPA requires, and its implementing regulations require certain things of agencies to comply with NEPA. We have, in 2014, we first enacted our NEPA implementing procedures. In 2018, we revised those procedures. So we operate under implementing procedures and categorical exclusions. And this is tying into the previous slide, we have our own obligations under NEPA, Nhpa, and other environmental laws. However, we also have to comply with the FCC promulgated procedures as well. So as a result of this kind of dual authorities, we decided in 2018 with our implementing procedures and categorical exclusions to more closely align those with the FCC procedures to avoid duplicative Nhpa reviews. Similarly for NHPA, as I believe probably earlier in the day, Jill or somebody else talked about, there's the program comment to avoid duplicative reviews. And we have that in our back pocket, and we use that for Section 106 reviews, or in situations that it's maybe not appropriate, or we have other projects that are not just telecommunication aspects of projects, we would then go forth and kind of do Section 106 in the more traditional way. Next slide. So just kind of a quick overview of our FirstNet's environmental review process. It's not drastically different from a normal process. We would receive an application for a project. It would consist of, project description, whether it was a co-location or a new build, locational information, responses to our environmental questionnaire, which basically kind of lays out the general, some basic extraordinary circumstance kind of things, and then any associated environmental backup documentation, which could consist of, Section 106 SHPA reviews, tribal consultations, ESA kind of reach outs to Fish and Wildlife Service or things of that nature. We would take and review that information initially to determine whether it was preliminarily going to fit into kind of the CADX or EA route. If it was to, if it seemed to fit within a CADX, we would take a look at the information that was provided in comparison to our extraordinary circumstances. If a CADX applied and those extraordinary circumstances were triggered, the project would be documented and a Nhpa determination would be, granted and approved. If an extraordinary circumstances were triggered or an EA was required at the outset, it didn't fit, it wasn't never going to fit within a CADX, something like that, then the project would go through kind of a normal EA and NHP review process with a public comment period and whatnot. The one thing to note, obviously, I'm again not familiar how familiar everybody is with FirstNet, but contractually, the FirstNet Authority at the outset has a contract with AT&T as our network partner to build out our network. So primarily AT&T would be the applicant. However, we do have every year we do have network reinvestment opportunities and or special projects that could involve other applicants. So when I say applicants, in most cases it's AT&T. However, over the course of the years, there have been other entities that would be deemed applicants. So next slide. And then just to talk about the kind of multi-agency environmental review aspect, which is kind of why we're talking about this today. So just at the outset, FirstNet Authority, we take a very active role in our obligations under Nepa and NHPA. We have that program and comment in place, which we do use fairly regularly. That kind of provides the burden to FCC to kind of go with their normal process, because most of our projects are just, a telecommunications project that's also going to be under FCC review. So to avoid that duplicative review, we use that program comment. However, additionally, the authority, when it comes to CADXs, we do internally review all of those CADXs for consistency and to confirm that any co-locations or anything like that was happening on federal land managing agencies or tribal lands, that those agencies had an opportunity to comment on those projects. And obviously, the typical federal agencies that we work with are the Forest Service, Park Service, BLM, BIA, and obviously tribal nations. So just in general, we have through our kind of interagency, working groups and things like that, and we have active and established relationships with the agencies. We also have tribal liaisons within our agency that we have strong relationships with tribal nations. In most cases, we defer that initial kind of review to the land managing agencies, whoever are involved, or the tribes that are involved. And we generally do this because those entities have it's their lands that they're managing. They have obviously expertise for those areas. They have relationships with the surrounding communities and whatnot. However, we try to make sure that in those kind of deferences or whatnot, that our obligations under Nepa, Nhp, and all the environmental laws are being met, so that we collectively are meeting our obligations. And then one last note is that, and I don't know if this was discussed earlier by Jill or somebody else, is that in some of those cases where there are other land managing agencies involved, is that there is that federal lands program comment out there, which allows federal land managing agencies to use the FCC NPAs if they so choose and agree upon. So in some cases, we will work with federal agencies who might wish to kind of forego their general environmental review processes and use that comment as appropriate. Next slide. So now I'm going to talk about the NTIA, which I also wear the hat of. So National Telecommunications and Information Administration, just a real quick overview. NTIA was created with the Reorganization Plan number 1 in 1977. I'm sure you're all familiar with that one. That was basically just a reorganization. There were a couple different kind of departments within the White House and within Commerce that were kind of amalgamated together to form NTIA under the Department of Commerce. NTIA is principally responsible for advising the President on telecommunications and information policy issues. And as a result, we'll work with other executive branch agencies to develop and present the administration on those issues. The primary aspect of kind of how NTIA gets involved in environmental reviews, NHPA and various other environmental laws is the administration of grant programs for the deployment and use of broadband and other technologies in the U.S. Next slide, please. Super quick overview. These are some of the past and present grant programs. In recent history, some of the previous ones was the Public Safety Interoperable Communications Grant Program, PSIC, in 2005. BTOP, the Broadband Technology Operations Program in 2009. Some current programs, Jomar mentioned some of these. We have the Consolidated Appropriations Act of 2021, which created the Broadband Infrastructure Program, BIP, the Tribal Broadband Connectivity Program, which is TBCP, and the CMC program, the Community Minorities, Connecting Minority Communities Program. IIJA, shortly thereafter, created the Broadband Equity Access and Deployment Program, BEAD, the Middle Mile Program, added funds to TBCP, and then there's 3 separate Digital Equity Act programs. Next slide, please. Our Environmental Review Authority. So as I mentioned, the primary Environmental Review Authority is based off of these the grant programs. And NTIA determined that through the administration of grants that those were major federal actions under NEPA, undertakings under NHPA, economic activity under ESA, and as a result was on the hook for all the other environmental laws. So this is a major federal action. So as a result, NTIA acts as a lead agency for these environmental laws. NTIA does not have its own NEPA implementing procedures or categorical exclusions. Therefore, we operate under the Department of Commerce's Departmental Administrative Orders and its existing categorical exclusions. Currently, NTIA is working with CEQ and Jomar and his team to establish our own NEPA implementing procedures and CADEXs that could expand upon and be more specific to broadband programs than the Department of Commerce's are at this time. So we're looking forward to working with the CEQ on that and hope that we can get those out here in the short term. Next slide, please. Quickly, our environmental review process, it's not overly complicated. You know, it's fairly normal NEPA procedures. So we would request as part of our grant program within the application that the applicant provide a detailed NEPA NHPA project description that talks about, you know, generally what the project consists of, how it's going to be constructed. Also maps, fairly detailed map set that kind of shows where in space and time the project's located. At that point, we take that project description and project map set, and we preliminarily determine whether we're planning on going the CADX or EA route. Again, if it appears that a CADX may apply, then we would request additional information from the applicant to provide some more detailed environmental information that could be, you know, compared against our extraordinary circumstances, environmental considerations, you know, typical things like endangered species, migratory birds, cultural, tribal resources, waters, wetlands, etc. And then also they provide, you know, information or you know, documentation on any consultations that have happened up to that point. Again, if the CADX applies and no extraordinary circumstances are triggered, project would be documented and with a NEPA determination. If extraordinary circumstances are triggered or an EA is required from the start, then the project would go through kind of a normal EA process or NHPA processes. And I didn't mention EIS. I just wanted to just briefly mention EISs are possible. It's not completely out of the realm of possibility. We try to stay clear of EISs and try to, at the worst case scenario, go the EA route. And that is not because you know, there's anything wrong with the EISs or whatnot, but generally our grant programs, because of funding, you know, the amount of the funds and the timing of kind of when the expiration dates are on with those funding, we generally think that an EIS going 2+ years might be problematic with kind of those timing and financing restrictions. So generally, if we see some major red flags or anything else that might kick something into an EIS, we would generally try to work with the applicant to try to rescope their project to make it, you know, at least at the onset, less impactful. Next slide. And just to briefly talk about the multiple agency environmental reviews. As Jomar had mentioned, with some of the interagency and kind of action plan type of things, we have robust relationships, I would say, with our federal partners. We work very early, try to work very early, closely and collaboratively with agencies and tribes in these processes, especially, you know, things that involve federal lands or on tribal lands. NTIA will always request that tribes or federal agencies are consulting or cooperating agencies in these environmental processes. And similar to like what I was saying with FirstNet, we will try to, as a result of doing that, we'll try to align our environmental reviews so that we're hitting all of the obligations that are required of the missions of those federal agencies and us as well, so that it's a streamlined approach where we're not doing two completely different environmental reviews. Additionally, on that note, we have executed a memorandum of understanding with the BIA, and that memorandum defines the relationship, roles and responsibilities, and that nature of kind of what happens when we have an environmental review, NHPA review or whatnot that involves both the BIA and NTIA. Concerning tribal, you know, government-to-government relations, we have a well-established and successful practices for early and meaningful outreach and communication with tribes. But not only tribes, also states, territories, local communities, other kind of stakeholders in the environmental and cultural review processes. We also have contracted with the FCC to use their tower construction notification system, the TCNS system, for our initial engagement with Indian tribes. And that is because the FCC system, the TCNS system, is a tried and true system that tribes are very familiar with. Works very well as far as kind of reaching out to those tribes with determining their areas of interest. And so we thought it would be best to piggyback, and we're grateful that FCC has allowed us to do that. Last point is that for similarly with FirstNet, NTA also is a party that's involved in the program comment to avoid duplicative reviews, and we don't typically use that on all of our projects. And the reason for that is because our projects are broadband, so we go beyond just the telecommunication of towers and whatnot. A lot of our projects are fiber optic projects, whether buried or aerial. And so the vast majority are those types of projects. However, we do have certain projects, certain applicants that are proposing towers and telecommunication aspects to address their issues. So we do have that in our back pocket for those types of telecommunication projects. So that's all I have. I look forward to answering any questions anyone has. And now I will send it over to Joe. Thank you.
Thank you, Andy, and thank you, Jomar. We started out today a little bit more narrowly focused on the FCC's environmental rules, but we thought it was really an important thing to finish the day because we get a lot of questions that will come into our office, and you'll just be a consultant or a project proponent will just be asking about a tower, and it takes a little bit of kind of question asking and fact finding to determine that there are other federal agencies involved. And the reality is we do work very closely with our other federal partners, and we want to make sure to talk to you all and get you sensitized to the fact that from our perspectives, and I think this is true of all of our federal partners, there really are some best practices for coordinating these multi-agency projects. We encourage you to identify all of the federal agencies who are involved in your project from the beginning. So what we see frequently, Andy's mentioned it, towers that are proposed on federal lands, and Jomar talked about it as well. Also towers, sometimes there are towers that are specifically and directly funded by another agency, and a great example is FEMA. FEMA funds specific towers. There are towers, as Andy was describing, that are part of a larger project funded by another agency. You're going to see a lot of NTIA-funded projects. Towers that are part of larger projects that are otherwise administered by or otherwise reviewed by another federal agency. We have recently had a couple of different projects where the Office of Surface Mining, Reclamation, and Enforcement had done EISs because they were looking at repurposing mining lands. And then in a part of that project was to put communication towers out there. And so it took, again, in some of these cases, our not initially realizing that it wasn't just a tower project, but it was part of a bigger effort. And that can help you get through the review process, and it really can help us help you. So, and then finally, towers on tribal lands. And I have a section to talk about from the FCC perspective, how our rules apply in those cases. So we encourage you to research the requirements and potential efficiencies. Like, first of all, identify all the federal agencies, then take a look at what their environmental rules are, and then some of these tools that Andy has mentioned at a high level, how NTIA and how FirstNet view them. I'll talk a little bit about how the FCC views them, and develop a plan. And then it's very important to communicate with all of the appropriate agency officials and gain consensus on how to meet the environmental review obligations. We all want to help you get through the process as quickly as possible, and as Andy emphasized, I think, just make sure that the agency obligations are met and you're doing kind of what needs to get done. So next slide, please. So one of the things in our rules that can be helpful is we do have a federal agency exception for Nhpa, and that is that an EA need not be submitted to the commission if another agency has assumed responsibility for determining whether the facilities in question will have a significant effect on the quality of the human environment, and if it will, for invoking the environmental impact statement process. So usually that is if another federal agency is doing an EA or is doing an EIS or potentially has done a programmatic EA and already considered towers as a part of that project or as a part of that study, that review. Next slide. So Mike, I think, very thoroughly and effectively discussed the antenna structure registration process, and he mentioned the fact that there is a separate environmental notification requirement as part of our ASR rules. So it's kind of beyond Nhpa, and that requires local and national notice for antenna structure registration applications. And similar to the Nhpa federal agency exception, there is an exception from that environmental notification requirement when another federal agency has taken responsibility for the environmental review of the project. Next slide. Andy has mentioned it. I'll just talk about it in a little more detail. There are several program alternatives that are very helpful in multi-agency Section 106 reviews. One is the program comment to avoid duplicative reviews for wireless facilities. This was initially issued in 2009. It's been amended in 2015 and 2020 because it was so effective. It initially came about in the American Recovery and Reinvestment Act era when NTIA and RUS were going to be funding large broadband projects that had tower components. And so this is a program alternative that removes the review responsibilities for certain named agencies when towers or other communication facilities will be undergoing Section 106 review under the FCC's NPAs. So what started with just NTIA and RUS and FEMA named in the initial 2009 program comment has now expanded, and you can see there Department of Homeland Security, Federal Rail Administration, Federal Transit Administration, as well as FirstNet and the Office of Surface Mining Reclamation and Enforcement are all named. The Advisory Council also has the ability to amend the program comment to include additional agencies upon their request. And the program comment would expire in 2025 unless they elect to extend it, which they likely would. Next. So there's another program comment for communications projects on federal lands and property, and this was issued in 2017. It actually allows federal land and property managing agencies alternative Section 106 procedures for communication activities on public lands and property. So it may eliminate Section 106 review where the proposed project is going into an area that's been previously surveyed or previously disturbed. There's a reference there to the section in the program comment with the details on that. Importantly, it incorporates provisions of the Commission's NPAs, and that's important because our NPAs themselves don't fulfill other agencies' obligations. So this kind of gives the federal land managing agency a way to follow our same procedures, even if they are not named in the broadband program comment. It also stipulates that where the FCC has a Section 106 responsibility and the federal land managing agency is following these provisions, it removes our responsibility. So the project is going through Section 106 review as part of the broader land managing agency's undertaking. And that program comment expires in 2027. Next slide, please. So now to talk a little bit about the environmental review for FCC facilities on tribal lands. Another federal agency that is frequently involved in these facilities is the Bureau of Indian Affairs. Certain tribal lands are held in trust by the BIA, and the FCC, treats deployments on trust land that are administered by the BIA similarly to other lands managed by federal land managing agencies, and we may defer to their environmental requirements using that 1.1311E stipulation in our rules that I mentioned already. So in those cases, the BIA would be the lead agency for Nhpa. And again, you wouldn't need to go through our Nhpa checklist process or consider an EA under our rules where the BIA was taking the lead. And in these cases, the BIA would also be the lead agency for Nhpa. Next slide, please. So if antenna structure registration is required for projects on trust lands, again, you should indicate in your ASR application that another federal agency is taking responsibility for the environmental review. And you should confirm, if you have any question about it, with FCC staff that the environmental notification process exemption that Mike discussed in detail would apply. The FCC's environmental rules do, however, apply if the BIA doesn't assume responsibility for environmental review on trust lands, and that would include tribal lands where the Hearth Act applies. Next slide. So the discussion about the BIA and BIA serving as lead agency applies to trust lands. The FCC is the lead agency for projects that are proposed on private lands within reservation boundaries. And for Nhpa, the applicant would complete the FCC's Nhpa checklist in order to certify that there will be no significant environmental impact, or use that checklist to determine that it needs to submit an EA. Towers requiring ASR are generally going to require environmental notification in these cases. With the Nhpa, I think we've discussed in several sessions today that the NPAs don't apply on tribal lands unless the tribe agrees to follow them. So you should talk to the TIPO in the first instance about whether or not they would elect to follow the NPA provisions. And then the Nhpa allows the tribe to assume SHPO responsibilities when they are a part of the National Park Service's Tribal Historic Preservation Program. So NPS-affiliated TIPOs act in lieu of the SHPO for Section 106 review of projects on tribal lands. And other projects would be jointly subject to TIPO review and review by the SHPO in the applicable state. Next slide, please. So Andy mentioned this, and we did want to mention it as well. Our TCNS system, which we have talked about several different times today, it's proprietary to the FCC, and back starting in 2009 under that same Recovery Act era that resulted in the broadband program comment, the FCC at that time extended the use of TCNS to NTIA and RUS to provide notifications to the tribes and facilitate those projects' deployments. Similarly, in 2021, we again agreed to extend TCNS support to facilitate NTIA's tribal broadband connectivity and broadband infrastructure programs. And so this ensures that tribes receive the initial project notifications from NTIA and not from the grant applicants. It ensures that the tribes who have expressed interest in specific geographic areas receive the information about the proposed project and the opportunity to comment in a way that they are familiar with and comfortable with. Next. And I think that is it.
Great, thank you very much. We don't have many questions, I think, because it's the end of the day, but we had one question for Andy, if you could put your FirstNet hat on. How does FirstNet address co-locations on non-compliant towers?
So that's a good question. So we we pretty much require that they are compliant, in short. We don't, yeah, I mean, in a nutshell, we just make sure if we can identify, we require that the, okay, let me start over. We assume that they are compliant. If we have determined, and that is part of the process in, as part of the application process, that the applicant has made a determination, has done the due diligence to confirm that they are compliant. So that's the first part. Second part is if there was a determination that was not compliant, then we pretty much, they have to go through that compliance process to make sure that it is compliant, just as we would if it was a new construction tower or anything of that nature. Hope that answers the question.
Thanks, Andy. We had one more question for Andy. Does NTIA file their projects in TCNS instead of the consultant?
We do. So how it works is that how we recognize it is that NTIA is required, has a obligation has a federal obligation for both SHPO consultation and tribal consultation. And that we must make that initial reach out to, in this case, the tribal entities. So we input the information into TCNS. It's coming directly from us. That initial consultation and notification happens. We do ask that because of the, just the sheer volume of grants that we have and the number of environmental people we have working for us, we ask that the applicants will take on some of the kind of the day-to-day aspects of some of those, not the initial notification, but the kind of back and forths of, for instance, if a tribe requests some additional information or something of that nature, then we would expect the applicant could reach out to the tribe and provide that information, or if the tribes have any questions or certain things like that they're more familiar with, instead of us being the middleman, we would ask that the applicant kind of deal with those day-to-day questions and things of that nature. However, if at any point a tribe wants to work with us directly, if at any point the tribe does not want to work with the applicant, we are more than happy to suspend the applicant being involved with that process and working directly with the tribe to resolve any issues or concerns or anything of that nature.
Thanks very much, Andy. And that's it for questions. So Garnet, back over to you.
Thank you, Andy, Jomar, and Jill. That was very helpful. Thank you. And this brings us to the end of the day and the workshop. So I want to thank everyone again for participating, those coming here in person, and of course those that participated virtually. So I wanted to thank everyone. As I said earlier today, the slides and the recording for the workshop are going to be available on our website. So if you missed anything, come back and check, because there was a lot of material here. So again, that will be available for you. And if you have further questions, please feel free to reach out to the staff at the FCC. And thank you again, and I hope you have a nice evening and safe travels.